and welcome back to my channel where we are all crime all black, all the time.
And hammer these points home and say that Investigator Viverito selectively paused this and didn't provide any explanation to the jury, and I was going to go after it. The state and Mr. Abadi, and we've had discussions, and I can see from their perspective that they took it out based on my email, and they took out the collage video, and there was probably some miscommunication between the two sides about, again, I never even knew that they were correlated. So I do acknowledge, I do believe what they're saying, and they're saying, well, we kept it out because you objected to it.
Right.
So just like earlier in the trial where I put something in the evidence that had a blank bubble for the date, and then it turned out, well, that was based on rulings. It wasn't me trying to deceive. I just want the truth out at this point. So my suggestion is I'm going to leave it alone on cross, and then the state on redirect, if they don't want me to go into it and create an impression, if that's what they want, I'll leave it alone on cross, and on redirect, they can have Investigator Viverito explain how this came to be and clear it up that it wasn't actually a post that looked like that, but it was part of a bigger post and all that. That's my proposal.
That's fine, Your Honor. We can bring in. Okay, sorry. We can bring in the video during our redirect of Investigator Viverito. We'll bring in the entirety of the. And I want to be clear, Your Honor. This is. I know Mr. Shard is calling it a collage, but it is the Instagram stories that we've referenced multiple times, that these stories are only kept up for 24 hours. And so on the top of the video, you'll see 18 hours, 1 hour. That is how long the posts have been up. And at the time Investigator Viverito recorded the video, the post would have been within 1 hour of her actual screen grab of the video. So for example, she screen grabbed this video on March 16, 2022 at 9:53:19 p.m. The specific video that we are talking about was posted 1 hour before. So it would have been posted around 8:53:19 p.m. on March 16th.
The story.
The story would have been posted.
Right. Do you have any way to know when the individual pieces of the story were originally posted?
So that is when it would have been posted, because they only run in 24-hour increments. So when it says 1 hour, the post had already only been up for 1 hour when she screen grabbed.
So the whole story, I understand you're saying, was posted within 24 hours of the screen grab. What about the individual pieces of it?
So it tells you. So
do you understand what I'm asking?
I am.
Okay.
Let me share with you, because I think it's better if I show you and then I can describe it. you able to see this, Your Honor?
Yeah.
So you see right here, Your Honor, it says 18 hours. If I- can't see. Okay, at the top, do you see where it says 18 hours? Would you see where it says, bitch, it's lizard?
The white, yeah.
So when it says 18H,
Yeah. Uh-huh.
that is 18.
Time to wake up.
That is 18 hours before she screen grabbed it. So here was this video, March 16, 2022.
Right, that had been up for 18 hours in my stories.
In the story. So when you go to the specific post that he is posting,
I've been here through it all. I won't fuck with you often. Baby, I ain't got no reason. I think I need to stay down. I done came back from the death, wipe off the leaves. I don't want any of these less from off the street. I fucked her the first night and then I never called again. Instead of out to see me, I was riding with a friend.
I was gonna have my page private, but you know what? Now I don't give a fuck. But y'all pussy. Don't even come from no fake page. Come from your real page. I don't get no fuck, man. Come on, man. Hey, it ain't private. It ain't private.
so then 2 hours later, he posted this picture, which says 16H. And then 11 hours later, he posted this pic. So
I'm a bloody man, I don't feel shame for all them niggas dying. Holding on to my name when they claiming. Through the night I'm crying. These bitches lying, let's face the fact. Them bullets flying, let's talk about that. Can grab my strap, bye-bye shot back. I feel the pain of the end. When I did my time, I ain't feeling it. Was
so 10 hours later, so he kept posting on his story as time passed. And so this is 8 hours later.
Okay.
And this is what they want me to do on Steller Heights. I might die. Never get on another fucking roller coaster day in my life.
oh, you talking about? I don't want to talk. I won't speak on that, I'm too official. I heard your niggas let them choppers off. Strictly about beef. I go to war with any nigga. I heard them say that they won't smoke with us. Ain't got better nigga, ain't gon' fuck with us. So what you saying is up. I step on any nigga. Name a block ain't hit, name a hoe ain't hit. Name a nigga don't try this shit to survive this shit. Every nigga don't try this shit, don't die this shit. On my mama ain't lying for shit. Hold up, shit, bro, true shit. Fuck, I look.
And so that's the entirety of the stories that she put. She took a video grab of all of the stories that he had posted when she was grabbing the Instagram.
Okay, and so I'm woefully ignorant about Instagram, but does a human being have to select what gets posted, or is it Instagram doing it?
So he posted a picture, and then say if he wants that particular song, he can add the song, and then you have options when you add the song. You can either add the song with words, you can add the song without words. That is his choice, his or her choice, to add whatever content to put on the picture
Okay.
that they're posting.
Okay, and so at that time, it's not like it just pulls something that you posted, 3 years ago and says, "Oh, would you like to look at this today?" Okay. All right, so if y'all are resolved to handle it the way Mr. Shart suggested, that,
Yes, we'll play the entirety of the video in regard.
okay.
And I do want to make the record clear, we would have played it regardless, but it was objected to and to be conciliatory and not waste the court's time and everybody else's time.
Yeah, I understand. And Mr. Shart understands too. He just didn't understand that that's where the screenshot came from to begin with.
That's why law enforcement writes reports.
Why
Or
defense
not.
counsel watches all the posts.
Okay. Okay, so back to the charges. I think we were on around page 18, bottom of 18, with parties to a crime. And I'd stated I was going to give it without limiting it to particular crimes. I just want to make sure that we don't have subsection D at all.
Are you on knowledge?
I'm on parties to a crime on the page, for me, it's page 18, 19. One point 42.10.
Yes, I don't think we need either.
Okay. Anybody disagree? We don't, D's not applicable? Okay. All right. So the next is 1.42.11. Defense objects to that. You want to voice the reasoning for objecting? Y'all need a minute to get there.
I'm here, I just have
Here.
missing pages.
Look here.
I don't think, the principle failure to prosecute, I don't think that's, applicable to this case. I don't think that it fits the evidence in this case. I don't believe that there's even slight evidence that, the principal has not been prosecuted.
So we've got a, number of different crimes. Including RICO, 2 murders. Let's see. And then I guess gang counts and gun counts for Mr. Stillwell. And then for Mr. Kendrick, RICO, 1 murder count. A gang count, and then several drug counts and a gun count.
I just don't know, in all those cases, I don't know of any principal, the murders, who they're saying were involved, everyone's being prosecuted, as far as, Mr. Kendrick in the house, in Mr. Williams' house, Mr. Williams was prosecuted, so I don't see any.
They don't know that. They don't know what happened to him.
They don't know what ultimately happened to him, but they do know he was charged. And my understanding, the way I read this instruction is just, if a principal is not charged.
Well, that's not what it says. May not have been prosecuted or convicted, may have been convicted of a different crime or degree of crime, is not amenable to justice or has been acquitted. It's like any of those options.
If it has been prosecuted.
It's not, and all of these have to apply. It's in any of these. And with regard to the Donovan Thomas murder, I mean, who knows what the jury's going to think, but it certainly could be applicable to that.
It could be applicable to RICO count, but can I fill it?
I think it's applicable. I'm going to give it over objection. All right, knowledge. What would this apply to? Because we're supposed to fill in the blank.
No, I don't think we need the knowledge charge. Or we, I should say.
I mean, it kind of seems to pair with parties to a crime.
In RICO, you know, if the jury believes that, not saying that the evidence has shown this, but I don't know what the jury's gonna, the way that the jury's gonna analyze the evidence, but if the jury believes that if they believe that Mr. Kendrick or Mr. Stillwell, you know, had knowledge of an organization called YSL, but were not actively involved themselves, or not actively doing things in furtherance of the RICO organization, I believe that that would apply.
Okay. Any others besides Rico?
Potentially, you know,
If it's everything, I'll just say the crimes, that the defendants are charged with, but
for instance, with the murder of Jonathan Thomas, they've shown Mr. Kendrick at the Texaco, a video of who they say is Mr. Kendrick at the Texaco. I know it's a live debate whether he was actually in the Infinity or not, but I could see it applying there as well. You know, Mr. Kendrick is quote unquote in the mix at the Texaco, but not actively participating in any crime that happens 5-10 minutes later. You know, and I don't know how the jury is going to analyze Mr. Stillwell on Windsor Street, but obviously he's in the area, and obviously I'm going to be arguing that he was not the shooter. So I think that it would apply there as well.
all right. How about to the drug counts for Mr. Kendrick?
But, yeah, potentially there as well, Your Honor, if there's some theory that Mr. Kendrick had knowledge of the drugs and guns in Mr. Williams' house.
All right, the gun charge, is that based? He's got the one gun charge, right? Or does he have two?
Let me look at the indictment again. There are multiple
57.
charges related to the guns.
Okay, so he's got
He
the,
has two.
Well,
He has three guns.
yeah, use a bunch of. So,
so his is based on, okay, the machine gun that's found during the raid, if you will. And then,
there's firearm during commission of a felony in 61.
right, but all of that is if they find that he, was guilty of possession of the machine gun and the drugs, whatever, then he's also,
Right, that's like a foundational thing they have to initially
right.
find.
So I would think it would honestly even kind of apply to that, although I don't know. Like the firearm he's alleged to have possessed is the firearms that are found during the search?
Yes,
Is that right?
that's correct.
Okay. All right, so with regard to giving this as to the RICO count, I'm not sure it's an accurate statement of the law for what RICO is, because if you're found guilty, or you can be found guilty of conspiracy to violate RICO, even if you don't know exactly what your co-conspirators might do in furtherance of the RICO conspiracy.
But you do have to intentionally join in on
Yeah,
that
but we're going to
conspiracy.
give specific separate charges about, you have to, about what you have to know to be found guilty of RICO, but it's not, this is not exactly true for RICO.
Not for the individual acts, each individual act.
Right.
I agree with that.
The state agrees as well, Your Honor.
But they're, well,
So I mean, it certainly applies to the murder counts, I would think.
and the guns and the drugs as well, I believe.
And the drugs, the guns, it's really like if they're found guilty of, like for instance, with Mr. Kendrick, if he's found guilty of the drugs and the machine gun, then he's also guilty of possession of a firearm by a convicted felon. But if he's not found guilty of either of those things, then he can't be found guilty of possession of a firearm by a convicted felon.
Right, that would be an inconsistent verdict for sure if that happened, but sorry.
What a-
Let me see.
For Mr. Kendrick, it's
It's all the weaponry. It's it-
it's
it's all
all
the-
of the firearms that were in
yeah.
Mr. Williams' house. But is he charged separately with possession of those guns, or it's just that?
Just.
Okay,
the only
so,
thing we charge separately is the machine gun.
okay, so, all right, then I guess if he's found guilty of possessing them, then he's found guilty of possessing them as a convicted felon.
So I'm trying to understand where the court has come out on whether that knowledge instruction applies to the gun and drug charges against Mr. Kendrick from what's at Williams' home.
I mean, there's the whole constructive possession.
Right, there is,
Law.
I understand that, and there's an instruction, I think there's an instruction on that.
There should be.
Um,
If there's not, we need to put one in.
I believe there is. But there's an intentionality in the constructive
Yeah.
possession as well.
Why don't we put a pin in this one and come back to it? So I don't think it can apply to RICO. I do think it applies to murder. Gangs, I don't
Well,
think it could apply to gangs. They either,
the gang charge against Mr. Kendrick, make sure I'm saying this correctly. Oh, that's 57. It's count 57.
Mhm.
It's based on the,
Possession
it's
of
based on
the
the drugs
guns
and the
and the
guns.
drugs.
Yes. Everything comes back, everything is founded on the drugs and the guns, or based upon that.
Okay, so. Right. I mean, the same for Mr. Stillwell. It's gang activity if he's found guilty of these crimes that would constitute gang predicates. Okay, so we'll just come back to that after we look at the kind of constructive possession charges. Okay. But it'll at least say, at the least, murder. All right, and so part of this knowledge charge includes a parenthetical that, if you weren't knowingly and intentionally committing, participating, or helping in the commission of, or were not a conspirator in, then it would be your duty to acquit the defendant. So the state's certainly alleging that everybody is a conspirator in everything if they are in the RICO conspiracy.
I think the court asked the question, we need to define it here.
Yeah,
I don't think we need to define
I
it.
think as long as we define it somewhere. Okay. All right, and then mere presence, everybody agrees. Mere association, everybody agrees. Multiple ways of committing a crime. It was requested by the state. Is there any opposition?
Well, we were talking about this, on our call on Sunday. As I always understood this charge, it was like for aggravated assault, like 2 different ways you could commit assault in this charge. I don't know.
We have it here in RICO because we've got RICO subsection A conspiracy and RICO subsection B conspiracy. I think that's the only place we have it. And so I would think this should come, within the explanation of RICO. Does everybody agree that's the only place it is here? Okay. So we'll give this charge, but it'll be within the RICO. And let's just skip over RICO for now. So we'll have to come back to that. All right. Attempt.
Which page is that, Your Honor?
I'm page 24, 2.01.11. So y'all had mentioned at some point needing to give some sort of a charge on every charge or, a definition for every charge that is an overt. Y'all still thinking that? Because I guess that's where attempt would fall.
Yes,
I don't see how else the jury makes the determinations of whether the overt or predicate acts were committed.
All right,
unless they
well,
have
I
the
don't think y'all,
definitions.
anybody has submitted what those charges be, so y'all need to get those put together like today. All right, so attempt will go wherever attempt goes in the explanation of the various overt acts. Okay, down to 2.0210 conspiracy, and then conspiracy additional instructions. Everybody agrees on those. Conduct in presence of the party. Everybody agrees. Okay, criminal gang activity. I have now made some suggestions. Y'all can see where things are rephrased. I don't think we have on 2.0225, we don't have any allegation that anybody is employed by the alleged gang, right? It's just associated with, so I've stricken through employed by. Everybody okay with that?
Yes.
All right, and then instead of everybody okay with commits a crime that constitutes criminal gang activity instead of the mumbo jumbo that is the pattern?
Yeah, I agree with the move to plain English there.
Okay.
Is that the highlighted portion?
So in, instead of participates in criminal gang activity through the commission of any criminal offense in the state of Georgia or any other state of the United States that constitutes criminal gang activity under OCGA 1615-3, just say, commits a crime that constitutes criminal gang activity, since we're going to define that in a minute anyway. All right, and then next thing we do is criminal gang activity means. The commission, attempted commission, conspiracy to commit, and then there are also possibilities for solicitation, coercion, or intimidation of another to commit. Do we have that solicitation, coercion, or intimidation alleged in this case? Okay, so I'm striking that. And then are y'all all right with the way that it's proposed there to just do kind of bullet points of to prove a violation of subsection A is alleged in 50 and 57?
Yes, Your Honor.
All right, and then element 4 would be a nexus between that crime and the gang. I'm not sure, most people might know what nexus means, but it's not like a word everybody uses. So I would kind of think it would be more helpful to the jury to include a little bit more than that. So what I did some research and found in 2 cases, Dixon and Rooks, where nexus was explained to be a connection between the crime committed and the gang, which we could say that way, or a nexus, a connection. We could also add the, that the crime was committed to further the interest of the gang. Now, Mr. Weinstein, I noticed that you had objected to the pattern on that, which, oh, okay, I'm sorry.
I was taking
Mr.
notes
Sharp,
for both of us. Your Honor.
the pattern says a nexus between the crime committed and the gang, that the crime was committed to further the interest of the gang, meaning proof that the crime committed was the sort of crime that the gang does. Are you just objecting to that last clause, or also that the crime was committed to further the interest of the gang?
I'm objecting to the last clause.
Yeah, I couldn't find it anywhere in the case law that that's what it
Okay.
meant. So I agree with you. That should not be pattern.
So we're going to strike was the sort of crime that
Well,
the gang does, Your Honor?
Yeah. So the choice at this point is a nexus between that crime and the gang. I could say a nexus that is a connection between that crime and the gang, or I could just say, or a nexus that is a connection between the crime and the gang. In other words, that the crime was committed, or that the crime was committed to further the interest of the gang. I mean, like basically any of those, any combination of those. What is the preference of the parties?
Can we write? So I
It's in front of you. It's on the bottom of page 29. If you have the electronic copy up that Ms. Percifield sent y'all
The language,
yesterday morning.
the language you have now is a nexus, comma, that is a connection, comma, between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang.
Yeah, that's just some language I pulled from Dixon and Rooks explaining what nexus meant. So I'm just saying we could use any of that and it would be.
That language is acceptable to
Okay,
Mr.
so
Kendrick.
you want me to just say it all?
It's exactly like it's written. It's
Okay,
fine with Mr.
so I'll
Kendrick.
just bullet point or whatever, element 5 will now be that. All right,
Yes, Your Honor.
Yes.
okay, you got it, Laura. Okay. All right, definition of participate, I'm kind of thinking, unless somebody on the jury says, what does it mean by participate? That they know what it means by participate. Okay.
Yes.
All right, and then criminals, definition of criminal street gang. Are y'all okay with the strike throughs? And I can say it all, but
I'm fine with, whatever, state's fine with striking.
okay.
Yeah, okay.
So I would, can you see it on his?
Your Honor, can you tell me the page again?
Page 30, bottom of page 30, definition of criminal street gang.
I think.
Okay, well,
uh,
so
it's going on?
the
Okay.
criminal street gang means any, this is the pattern, organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal activity. And I'm suggesting that the same concept is conveyed by saying criminal street gang means any group of 3 or more persons associated together, which is engaged in criminal activity, criminal gang activity.
Okay. It's just formatted different on my page,
Okay,
but it's the
sorry.
same thing. No, it's okay, Your Honor. I'm fine with that change.
Can I just make one?
Yeah.
Which engages in criminal gang activity, which is
Uh,
already been defined for you. Because I don't want the jury.
Criminal
to
gang
think of-
activity as defined. Have I already defined it by then? Yes.
In 25.
Sure, as defined.
To take a layman.
Can you stick that in there? All right.
Or maybe as defined in 225 to be more specific, but
No, because it's not
Maybe.
going to have those numbers
Oh,
when they
okay,
get
that's
the
right.
instructions. They won't have things. They'll just have the
Mm,
law. And then, it'll continue with the existence of the gang may be established by. And then the pattern suggests as charged in this case, criminal gang activity is, and then I'm supposed to list the crimes in the indictment that would constitute criminal gang activity, although I would only do the ones that they're alleged. So it would be whatever set forth in, I guess, 57, 50, 51, and 57, right?
yes.
So as charged in this case, criminal gang activity, I think it's charged in this case, blank, 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 constitute criminal gang activity.
And then those are going to be, you can say they're defined further down. 'Cause I think you're getting into
So
those
that would be
definitions.
murder, and 57. So it would be murder and then everything listed in count 57, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and possession of a firearm during the commission of a felony.
As will be defined for you.
So question here. Do you want me to say murder charged in counts whatever? Or just murder?
No.
Okay. All right. So then that brings us to 2.1010, malice murder. Y'all say you agree, no changes. We've got some parentheticals, rather it's the unlawful intent to kill, and then you're supposed to only put the ones that apply. And the choices are without justification, without excuse, without mitigation. Is there any argument that any of those things has been established, even potentially in the evidence? No. Okay, so it would just end with the unlawful intent to kill, period. All right, premeditation, y'all are in agreement, motive, agreement. Possession of a firearm during the commission of a felony. Y'all said you're going to tailor it. Let's just tailor it now. Had a firearm on his person or within arm's reach, right?
Yes, Your Honor, we charged it both ways.
While, there aren't any attempts, right, on the firearm things while committing the felonies of a crime against or involving another person, or a crime involving some of the drug stuff, right? None of the rest of them apply.
Yes, Your Honor.
Right.
Stuff, as I so aptly put it, would be possession or possession with intent to distribute.
Yes.
I guess the easiest thing to do would be just list those again. Possession of marijuana with intent to distribute, possession of marijuana or codeine with intent to distribute, or possession of cocaine.
Yes.
All right.
I'm sorry, could you give me that list again, Your Honor, that you just
So
read
do
off?
y'all want me to say, while committing a felony, which is a crime involving another person or a crime involving possession with intent to distribute or possession of those particular drugs, and then say, I charge you that certain of those drugs are a controlled substance, or just say, just get to the heart of the matter, which is if you find he did these things, then that would be possession of firearm during this type of felony. And then do I need to say, so my question is, do I say while committing a felony, which is a crime involving or against another person, murder is a felony, which I will define, or which I've defined for you, or do I just say while committing the felonies of murder or possession of these drugs?
I think the latter, Your Honor, is
Yeah.
cleaner.
It is
Yes,
cleaner.
I think so
It's
too.
simpler.
Everybody agrees?
Yeah, I agree with Ms.
Okay.
Silkman.
So yes, it would just say, number 3, while committing the felonies of murder, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, or possession of cocaine. And that's it. And then for purpose of this offense, a firearm includes any handgun. Do we have rifle, shotgun, taser, or stun? I know we don't have the rest of them. Do we have rifle involved at all? Do we know?
No.
Not for these two counts.
No, Your Honor.
Okay, so for purpose of this offense, a firearm includes any handgun, period. All right, we don't need, excuse me, 2.42.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, Unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like for count for the two counts, count 63 and count 52, while we did charge 133,
Yeah.
it is missing an element. And-
It's missing the indictment is missing an element.
Yes, Your Honor.
That was going to be subject to the motion.
And so we believe that the language as charged is a 131 charge and
So-
not a 133.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence that's established has the elements.
I
of
think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you law.
So either it's going to be, in my view, 133 or nothing unless y'all have law to change my mind. But assuming it's 133, I think it's possessed a firearm after having been convicted of a felony involving the use or possession of a firearm. And then I normally would have put blank as a felony involving the use or possession of a firearm. But we'll just hold off on that one until you come up with whatever law you're going to provide. Okay, possession of a machine gun. And I'm going to write this the same way the rest of them are written for whatever this offense is, and then here are the elements. Y'all dropped the language of the statute in. I'll just use those elements to do the kind of bullet point thing, okay? So it would say something like, the state must prove that the defendant possessed, or it's just possessed, a machine gun during the commission of those crimes. Okay. Tell Laura, just write me a note to rewrite it like the other ones are. Okay, 2.70.10. Y'all agree? So it's possession, right? Of marijuana or no, it's possession of cocaine, right? Y'all help me out here.
The possession charge is cocaine and 60.
Okay.
Um,
So it's possession of cocaine. The state must prove that defendant possessed or had under his control cocaine, which is a controlled substance, right?
Correct.
All right, then moving to 2.70.14. For possession with intent to distribute marijuana, the state must prove the defendant possessed with intent to distribute any amount of marijuana. And because it's a separate count, I would then do for possession with intent to distribute a controlled substance. It would say to distribute codeine, which is a controlled substance.
Yes.
Okay.
Yes.
And you're right, can we, I'm sorry, I was typing, can we go back to possession of machine gun?
Yes.
If you did not say, and I apologize if you did, I think we need to define machine gun, which would be 16/11/121.
Let me see what 1611/121 says. Does it give me a definition of,
Yes, it does, Your Honor.
well, that's very helpful. And obviously, I'll let y'all look at it again after. We put it together. Okay, so Laura, we can just go and lift that definition from that statute. It's in there. It's 1611/121. It's part of element 1.
Open my code section, got it, Judge.
Yeah. And then definition of marijuana, everybody's good with that. Did we have testimony that whatever was found was marijuana?
I don't believe y'all introduced any of the lab reports, did you?
The marijuana, now, there's no lab test, that is correct.
Okay, well, anyway. All right, and then there is 2.76.10, actual and constructive sole and joint possession. Seems that everyone agrees. So we've got parentheticals.
Your Honor,
Mm-hmm.
I apologize for not, the GBI analyst who testified about all of the pills, she also talked about she tested the marijuana.
Okay.
Okay.
So state must prove that defendant possessed the marijuana, controlled substance, or gun, right? Or guns, gun at issue in this case.
I'm sorry, could you give that list again, Your Honor?
I mean, I would think it would be the marijuana, I can just say codeine,
Codeine.
cocaine, and guns, firearms, because it's a machine gun too, guns.
Yeah, firearm, there's a half a dozen roughly, so.
Okay, on equal access. I would think it would be the same list of things. Do you want me to read both parentheticals, possess and put those items?
I mean, I'm fine with just possess, Your Honor, but
All right, well, since it's your client that's facing those charges, although not with the guns. Just possess and not put the items where they were found. That's an interesting one.
I just don't believe there's been any evidence introduced of
We're just going to go with possess.
putting. Or possessing, but that's neither here nor
Okay,
there.
if Moving down to 27630, if you find that the defendant owned or leased the, where would,
What's the second
Mr.
paragraph?
Kendricks is all the stuff that was found in Mr. Williams' residence, right?
Correct.
That's what he's charged with.
Yeah.
Mr. Stillwell is charged with what? The stuff that was found in the studio? Yes, no?
No.
What did I
Mr.
say?
Stillwell is-
Is it the reverse of that?
Yeah, he's not charged with it.
Isn't he charged with possession of a, oh, that possession of a firearm is if he committed the murder with a firearm.
Right.
Okay.
Mr. Williams, the thing that seems a little bit confusing about 27630 is it seems to be written from the point of view that one of the defendants is the owner of the residence. I don't know if.
It may not even be applicable.
Well,
I think it
it-
would be. I'll let Mr.
No, I think it would be applicable, but I think it would need to be altered somewhat because it's Mr. Williams that,
Well, I know, but that's better for Mr. Kendrick. If you find Mr. Kendrick owned the residence, well, he didn't. We all know that. Right? So then that part is not, I can read it or I can just not read that because it's not applicable.
yeah, okay, now I see what you're saying. Your
We
Honor.
could just say,
Yeah, I read it. So it probably isn't,
I just wasn't sure if instead of saying that the defendant owned an individual.
if you find that an individual owned or leased the residence
yeah.
where the all of
drugs,
that stuff
guns.
was found, then you may conclude that that individual possessed everything found there. However, if you find that others had access to the residence, then that individual, then the owner's ownership of the residence is not by itself enough to prove possession. Frankly, the whole thing's just not even applicable here.
Okay. You may,
Okay,
I don't object
so
to it
we
being
won't get
removed
that
then.
one at all. All right, affirmative defenses. The note is, defense believes this must remain. So I need some evidence
Go back.
to,
Mr. Stillwell keeps trying to trip me. Your Honor, I am taking a stance that, well, again, if there's a directed verdict or if there's some issue with the gun charge, then that solves this problem. This relates solely to the gun charge.
Mm.
We have heard testimony from the gang investigators as well as Investigator Thorpe. Woody's allowed to have a gun. Woody's allowed to have a gun to protect himself.
Oh.
People are shooting at Woody. It's okay if he has a gun.
oh,
And my stance is that we've heard testimony that people are repeatedly
Mhm.
trying to murder Mr. Stillwell. Mr. Stillwell is charged with possession of the FN 5.7 and he's charged with that. And our stance is, while it doesn't, it falls under F for justification, which is in all other instances based on similar reason and justice as those enumerated
and
in
can
this
you
charge.
give me a second to find where that's his count, what, 52?
52 and 64.
No, he's not even 52 and 64.
Yes, Your Honor.
Well, 52, 54, that one doesn't chart, that just is the murder. 64.
It really applies, if he's convicted of 52, or whichever the first gun charge is that's associated with the murder, then that clearly wouldn't be, fall under instances of reason and justice. But for 64, when it's a standalone gun, we have laws in place under the jury charge 30110 for justification. And my argument is that the jury charge F is applicable under 30110. Unfortunately, what's complicated is to understand F, you
Okay,
need to,
hang on just a second. So count 52 charges that on March 14th, he possessed a gun, and that was the drinks murder, right?
yes,
Count 64 charges he possessed a gun on the 17th of March,
yes. And that was on Meadowlark Drive. The
when
gun
he
that
was arrested?
right, right. The gun that the state is saying was thrown out the car,
Oh, which you've,
registered to Miss Alexander.
okay.
And my argument is if the jury finds that Mr. Stillwell was in fact carrying that gun around
Mm-hmm.
and either he or Mr. Nichols discarded it out the window, 30110 F would apply based and the reason it would apply to him specifically is because we have heard testimony about repeated attempts on his life. Now, the dilemma, if Your Honor were to agree with me about F, the issue is that it's reference to A through E.
Mm-hmm.
So we would have to give them all A through E, but just
Well,
make sure that they understood that I was arguing F.
well, it would only be A. It wouldn't be any of the other ones.
Yeah, you know what, you're right, Your Honor. I'm sorry. You're right. It would just be A.
Okay, but here's the thing with the law is that if he had been possessing a gun despite being a convicted felon and somebody came up to his window and held up a gun to his temple and said, you know, dance or I'll shoot you, and he shot them instead, then he might be justified not only in shooting them, but in possessing the gun that would otherwise be illegal for him to possess. He couldn't be charged with that. Well, he could be charged. He couldn't be convicted of that. But here, he didn't do anything that was justified conduct. You know what I'm saying? Because it's a specific reference to 16:3, 21, 23, 24, 25, and 26, which is using a firearm in defense of self, home, others.
My understanding of I think it's the Johnson case. It's the one that the Hogues argued and was the first one that dealt with the situation that you laid out with possessing a gun and then using it in self-defense, even though you're not. My understanding of that case is that you would have a justification argument for the act, the murder, the shooting, whatever it is, but you could still, unless you grab the gun in a sudden emergency,
Right.
you could still be charged with the gun. The difference that here, from my perspective, is the person in your scenario is just someone who's carrying a gun because they want to carry a gun and they're not supposed to carry a gun. Then something unexpected happens and they use the gun.
Okay.
My
well,
scenario-
He knows somebody's after him.
Right.
Do
that's
you
the
have any
difference.
case law to support
There
your
is no
argument?
case law I've been able to find.
Making law, huh?
Yes, making law. Someone has to make it.
That's true.
But F exists for a reason.
I don't think there's any law that says that. I mean, especially if Johnson is a case that says, if you're a convicted felon, unless you grab a gun in an emergency situation, you're not excused. Your toting it around on your body doesn't excuse you.
For the gun possession. And that is, in
Oh,
fact, what Johnson says, to
Okay,
my understanding.
well, I mean, unfortunately, there is not in the law any exception that says even a convicted felon who knows they have legitimate threats to their life can go to some government office and say, I've got legitimate threats. Let me carry this gun. That's
Well-
just not what the law is.
Of course, I'm going with the court, and I respect the court. I would argue that that's what F is. That's why F is there.
Hmm.
Because it says in all instances based on similar reason and justice.
Hmm.
And to me, this is similar to 16, 3, 21, 23, 24 self-defense.
I mean, I like your argument. It's a
Thank
good
you.
legal argument. It's clever. State want to be heard?
That's just frankly not the law. I mean, the law allows us to, we could charge him with possession of a firearm during the commission of a felony or by a convicted felon 3 different times, knowing that he had it before and knowing that he had it after if he left with a gun, but he can be found immune from possessing the gun during the alleged whatever act he was justified in protecting himself with. But you can't just carry a gun around as a convicted felon and not be held accountable for it unless you are found to be justified in using the gun at the time in which you fired it.
All right, I am not going to give that charge. If you want to perfect the record any further, you can go ahead and do that. But I think it's pretty clear what your argument is.
Yes, Your Honor.
All right. So we will not be given 3.01.10.
In that case, and just for the record, I'm not acquiescing. I'm maintaining my argument, but just in all candor to the court, then we probably don't need 30000.
Okay. Or 31010.
Correct.
All right. And we clearly don't need 31011 because it doesn't even exist anymore.
I don't think we need any of these
All right.
justifications.
I don't either because they all are like basically if they're so no 1-2 and no 1-3. All right. Then venue. Should be indicted and tried in the county in which the crime was committed. I'm going to strike the except as otherwise provided. We don't have that, do we? And then venue for Rico, y'all are both in agreement that the one that's listed is fine.
Yes, Your Honor.
Okay. Venue for conspiracy to commit a crime. Other than Rico, nobody's charged with conspiracy to commit a crime as like a separate offense, are they?
No.
So do we need this charge? Venue for conspiracy to commit a crime?
We would not seem to.
I don't think so either. Okay. All right, I need verdict forms or suggested verdict forms. For 1.60.12, multiple defendants all, and it says adjust. Do we want that at all? What is anyone proposing on that?
I don't want that at all. Because I believe that is, I think that's covered in the next.
I mean, I'm going to tell them determine guilt or innocence of each defendant separately.
I don't believe that this is necessary.
Okay.
And I'm sorry, y'all, which part is not necessary?
1.60.12. Do we need that? It's way too hot in here. The defense is no longer requesting it if they ever did. Is the state still requesting that?
You said 1.60.12, correct?
Yeah.
Multiple defendants.
Right. Given that we're given the charge below about assessing the evidence against each defendant that the state requested.
We don't need 1.6.
Right. All right, assessing the evidence. It appears the state requested it. The defense is fine with it. And I assume the state still wants it, given that you requested it.
Yes, Your Honor.
Okay. Court has no interest, no sympathy. Sentencing, responsibility for, state questions why I don't want to give that. Because if I'm telling the jury, don't concern yourselves with punishment, then why am I telling the jury anything about punishment? It's like, don't think about an elephant.
Because
It also seems to suggest that there's likely to be a conviction
well,
come from the court.
I think because human nature, people will think we don't instruct them that they're not charged with what happens after the guilt innocent phase. And I think that's why this jury charge is important, because they may, in my experience, sometimes think about sentencing and think about what happens after this point, and am I responsible for that? So I believe letting
So if
them
they
know-
ask us that, then we'll say, don't concern yourselves with that.
I think innately, especially with a count like murder, where people know what the penalty is, that's typically what the request.
People think they know what the penalty is.
Right, but I guess because the people think they may know what the sentencing range is or what the penalty is, which is a life sentence. A lot of times that can come into how they view the evidence and things of that nature, and how it can be a factor in their decision making, which is why we request it.
To me, that's covered in sympathy. They're not supposed to have sympathy towards.
Okay, well, I don't ever give it, and I'm not giving it here. If they're not supposed to think about it, then I'm not raising that. All right, and nobody has any issue with deliberations or unanimous verdict. State, there's a note, state will be adding additional charge on consciousness of guilt flight. Do y'all have that ready?
It's not permissible.
Okay, well, we'll need to get that.
We're not.
Oh, you're not going to do it. Okay,
It can be argued, but yeah,
okay.
of course not to do a charge on it unless the defense requests it.
All right, so jumping back up to wherever knowledge was. I don't know where it was. I think it might have been before the RICO charges.
Page 19.
Yeah,
Thank
page
you.
14310 on 19.
Okay, thank you. All right, so it seems that the knowledge that would be necessary for the drugs and the guns is explained within those kind of possession charges. Do y'all agree? Or what do y'all think? Anyone?
Our preference would still be to keep that knowledge charge in. especially, I understand that
I'm asking which crimes do I say it applies to?
the murder, the drugs, and the guns. Did I leave anything out?
I think D, all of the above.
No, I left out the RICO.
And, the Rico.
And the gang, which.
Well, the
wouldn't
gang
even
is,
It wouldn't even make sense for the gang.
no, so the murder, the drugs, and the
Okay,
guns.
so
Your Honor.
knowledge on the part of the defendant that the crime of murder, I mean, I think it might be appropriate here to say murder in count whatever, murder in count whatever, possession of whatever it was, drugs in count whatever. Do y'all think? Was being committed and that the defendant knowingly and intentionally participated must be proved by the state beyond a reasonable doubt. If you find that they had no evidence that the above listed crimes were being committed, or that the defendant did not knowingly and intentionally participate or help in the commission of the alleged offense, I don't think we need conspirator there because conspirator gets covered in the RICO.
Yeah, we don't need that.
Okay. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of listed, then you would be authorized to convict the defendant of that count I'm going to add that.
Yes,
Okay.
thank you.
All right. Anything else we said we were coming back to? Obviously RICO, but anything else?
I sent the proposed charge to Ms. Percival and council as it relates to count 51. Mr. Stillwell is charged with 1654 subsection B. And I sent a proposed charge as it relates to that count. It's not covered by the pattern.
That being gang.
So the pattern covers 16154A. It doesn't cover B.
Isn't that in our gang? It's, if you look at what's there.
It's already in here.
I'm sorry.
I did, where is it? Yeah, there's, to prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, the state must show blah. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show it's all of those plus, in order to, there's an additional element number 4 in order to maintain or increase his status or position in the gang.
I'm sorry, Judge.
This covers that, right?
I completely.
Okay, it's okay. All right, anything else?
Could I have 5 minutes before you bring the jury out, Your Honor?
Yes, I
Thank
mean,
you.
we've got, oh, right. We told them 10. Do we know whether they're all here? They're not all here anyway. So yes, you can have until they get here.
Thank you.
We can go ahead and get the jury in. Thank you. Good morning. Can you pull that mic that's got the red on? Thank you. Everybody can be seated. Go ahead, Mr. Sharp.
Thank you, Your Honor. May it please the court. Good morning. Good morning.
Good morning.
Investigator Viverito.
Good morning.
Are both those mics being used?
This one is,
It's fixed.
Yeah.
Okay. All right. Thank you. So Investigator Viverito, where we left off yesterday, we were talking about a post that was captured by you that showed Quamarvius Nichols with some writing on the picture, correct?
correct.
Okay. We are going to get back to that later.
Sure.
Okay. So we're going to switch to another topic right now. But it is about the posts from March 2022 that you collected.
Okay.
Okay. The reality is in March 2022, you observed and collected some posts that you felt were relevant
Sure.
and that you felt were derogatory or mocking both the Christian McMiller and Darius Ford situation.
I'd have to see which posts were.
Well, we're going to get to individual
Okay.
posts, but some of the posts were derogatory and mocking Christian McMiller and Darius Ford.
correct.
And then you also pulled posts that you thought were derogatory or referencing or mocking Shamel Drinks' death. Is that
Correct.
correct? Okay. And let's be clear. As an investigator, you are not saying just because someone posts something derogatory or mocking or referencing the death of another individual, that means that they committed that crime. You are not saying that, are you?
That is correct.
Okay. And I just want to talk to you about a couple of these posts. I'm going to bring them up to you, okay? These are all this is a bundle of the posts that you collected that are in evidence, correct?
Sure.
All right, may I approach?
Yes.
For instance, you observed some posts that were made following the Christian McMiller Darius Ford double homicide
Correct.
on March 10th going into March 11th. And these posts were in the days following.
Correct.
Okay. Ms. Knight, could you do me a favor and publish what's been admitted as 457 VV? Okay. Um, Investigator Viverito, this is a post posted by one ABG underscore Big Nick, correct?
Correct.
And you know this person from the picture and also from his name on Instagram to be Nicholas Johnson.
Correct.
Okay. And in this post, when was this post collected by you?
That was collected, would have been around 8:20 on March 11th.
March 11th. Okay. So this is the morning after Christian McMillan and Darius Ford were gunned down.
The evening, 8:20 p.m.
Oh, I'm sorry. Okay. The evening after.
Correct.
About 20 hours after, 21 hours or 19 hours after.
Somewhere around there.
Okay. And this post includes a says slime and chalk.
Correct.
Okay. And you viewed this as a clear reference to Darius Ford and Christian McMillan being murdered in reference to a chalk outline of a body on the street.
Correct. Coupled with my knowledge and interactions with Mr. Johnson in the past, yes.
Right. I think you testified that Mr. Johnson, in your opinion, he is associated with Atlanta Blood Gang.
He's documented as a member, and he's also a fixture at 12 Atlanta Daily.
Okay. So you saw this post, posted the next day, referencing the death, mocking slime and chalk. Mr. Johnson has not been charged for the murders of Christian McMillan and Darius Ford, correct?
Correct.
And the reason he hasn't been charged is because posting something like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMillan and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all of the situation. Get to it when I get to it, okay? But I'm asking you specifically about posts. Posts that is not a confession to killing Darius Ford or Christian McMillan, is it?
Absolutely not. But as an investigator, look at things as a whole to piece things together, leading you to six. So,
Okay, and that's why you collected this.
correct.
Okay. Miss, Knight, I'm going to ask you to publish 460 DV. Okay. 462 VV is two posts that showed up on this page labeled Joey_Hurst24, correct?
Correct.
All right. And on the left is Christian McMillan,
Correct.
and on the right is Darius Ford.
Correct.
And they're fairly self-explanatory. They're mocking the death of Mr. McMillan and Mr. Ford, correct?
Correct.
All right, and this was posted when?
I'd have to see the file name.
Okay, so you're not, and that's fine. Was it posted after the death of Christian McMillan and Darius Ford?
Yes.
Now, I understand your belief is that this is a trolling page or a fake page. Is that correct?
It's a page. Yes, it's a page that we had not seen surface really or be vocal until this point.
Now, and certainly when you see a page like this, there are certain investigative things that you could do to try to determine who is behind this page, correct?
Correct.
You could subpoena Instagram, you could check IP addresses to see who set up the page, etc.
You could.
Okay. You or anyone else that you know of did no such thing to try to determine who Joey Hurst was? The
No.
government name. Okay. And the reason you didn't, and I'm not trying to beat you up, the reason you didn't go through those steps, if you thought this was a confession, and you thought this meant that Joey Hurst killed Mr. McMiller and Mr. Ford, you certainly would have gone through those steps to uncover who it is behind this post, if you thought that was the killer.
If I thought that was, but the investigation led us to other suspects.
Okay. The bottom line is, you did not view these posts as signifying that whoever was behind this account was the killer of Mr. McMiller and Mr. Ford. You didn't view it that way.
Correct. The individuals that were making posts who we deemed as suspects, they were further investigated, whether it be cell phone extractions or social media.
Okay. 456 VV. Please, Ms. Knight. Thank you. Okay, and this post was collected on March 11th, 2022 at 11:30 p.m., correct?
Correct?
Okay, so again, about a day after Mr. McMiller and Mr. Ford were killed.
Correct.
Okay, and you testified on direct about what you thought new op pack just came in. It's kind of like we're smoking on our ops.
Correct.
Okay. Certainly not kind, not nice, not sympathetic, and it's showing approval for what happened, correct?
Correct.
Okay. And this page is another one that you didn't know the government name of the person behind it.
Correct.
Okay, and you didn't go through any investigative steps, or anyone else that you know of go through any investigative steps to determine the person behind it.
Correct.
Okay, and the reason again is because this post, you didn't take it as a confession. You didn't take this post as saying, I'm the person who did it.
Correct.
Okay, cool. Finally, we're going to talk about Kelvin Watts.
Okay.
Okay, Kelvin Watts has not been arrested for the Christian McMiller or Darius Ford murder, has he?
He has not.
Okay. And this has all happened 2 years ago at
Correct.
this point. Okay. Really 2.5 years ago, more than 2.5 years ago. Mr. Watts made several posts regarding the death of Darius Ford and Christian McMiller.
Correct.
Okay. Ms. Knight, could you please publish 473 VV for me? Okay, in 473 VV, that's posted by Shellkel Nutlife, correct?
Correct.
And you know that to be Kelvin Watts.
Correct.
And this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
Okay, and this actually depicts Mr. Donovan Thomas.
Correct.
And underneath Mr. Thomas's left eye are 2 shells.
Correct.
Okay, and as an investigator, you're aware of like prison tattoos or eye teardrops under an eye, correct?
Yes, that's what I spoke about on direct.
Okay, right. And you took this as kind of a play on the teardrops under the eyes of 2 shells indicating 2 bodies, Darius Ford and Christian McMiller.
Correct. The first time we started seeing the 2 shells under the eye was after the death of Christian Ford and Darius McMiller, I think in days following.
Okay, Ms. Knight, could you please publish 461 VV? And here's another picture of Shellkel or Kelvin Watts that posted shortly after the death of Christian McMiller and Darius Ford, correct?
Correct.
Okay, and these are, you got to look a little close, but I see the big shell off of his hair, but then there's two little shells under his left eye.
Correct.
Okay, and again, that's a post that you interpreted to be a reference to the death of Christian McMiller and Darius Ford.
Correct.
Okay. Ms. Knight, if you could publish 454 VV, please. Okay, in this post, again, shortly after the death of Christian McMiller and Darius Ford, correct?
This was in the hours after they were killed. Yes.
And this is on Kelvin Watts' page.
Yes.
And again, we see the two shells.
Correct.
Okay, and that had significance to you because there was two dead bodies.
Correct.
Okay, thank you. And 460 VV, please, Ms. Knight. Okay, again, here, this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
And we have two shells, right?
Correct.
And we have a smiley face, except the lips are zip tied or zipped up, I guess,
Correct.
and a black heart.
Correct.
Okay, and this was on Mr. Kelvin Watts' page.
Correct.
All right. Also, and Ms. Knight, thank you. Also, you're aware that Kelvin Watts has made a song that references Christian McMiller and Darius Ford, correct?
He may have.
You never heard Mafia Story by Shell Kel and Third World?
I haven't, but it would not surprise me if he did.
I heard my ops died like some thoughts, referring to two snakes dying with their eyes wide open and their tongues out. Crime scene nasty in a fast car, died in empty traffic.
That sounds about on brand for Kelvin Watts.
Okay, and that was a reference to the Kia Stinger, the fast car is Kia Stinger that Mr. McMiller and Mr. Ford were in.
That sounds about right.
Speculation.
Were Mr. McMiller and Mr. Ford riding in a Kia Stinger?
Green color Kia Stinger.
Okay, and were they in fact shot on the highway?
Yes, they were on the highway.
Okay. Mr. Watts, despite these 4 posts that you collected and this song, has not been charged with the murder of Christian McMiller or Darius Ford, has he?
No, he has not, but that's also an open investigation that's not assigned to me. So
Okay, that's fine.
But-
So, but the answer is he has
He
not
has
been
not.
charged. And it's just 2 years, 8 months later.
it's still open active investigation.
Right, and you've had you collected these postings that Mr. Watts made way back in March of 2022.
Correct, but so investigations, just the social media posts aren't enough to arrive at probable cause. You need him maybe on video at the crime scene, before that murder, things of that nature. So if the social media was enough for probable cause, a lot of people probably would have gone to jail for this, but we don't do that.
Right, because there were a lot of people posting on social media.
Correct.
A lot of people posting horrible things on social media.
But unfortunately, nobody was on camera at the scene or there, or there was no knife.
Agenda today, and I know that you want to talk about the security cameras, and we will absolutely talk about the security cameras. I promise you.
Commentary and
Well,
Clean up some. We're going to shift off of social media, and we're going to get to the wiretaps.
Mhm.
Okay, I want to clear up some issues, or not issues. I want to talk about the wiretaps and what we talked about Friday and yesterday. You had a wiretap. I understand you had one on Mr. Sumlin's phone. I'm not going to be talking about Mr. Sumlin's phone. We're talking
Okay.
about Demekion Garlington. Okay?
Okay.
All right. Do you have the number for the total number of calls recorded or listened to during that wiretap?
I don't know off the top of my head.
Okay. Was it in the thousands? Is that fair to
Probably in
say?
the thousands, yes.
Okay. Do you know how many total calls Mr. Stillwell was a party to?
I couldn't give you a number, but it would probably be not as many as others because he went into custody, I think, within 6 days of the wire going up.
Fair enough. And just so we're clear, when you apply for a wiretap, you send something to the phone company, correct?
Correct?
And the phone company is told not to inform anyone about the wiretap, certainly not to inform the subscriber.
Correct.
So no one, to your knowledge, no one told Mr. Garlington that he's being recorded,
Correct.
okay, because that would defeat the purpose of the wiretap, right?
Correct.
And to your knowledge, no one told anyone else that there was a wiretap on Mr. Garlington's phone.
Correct.
Okay. Now, the state referred to the calls that were played for the jury yesterday as a sampling. What was played to the jury wasn't exactly a random sampling of the calls, was it?
No, all of the calls were turned over, and it's my understanding that they had to be narrowed down.
Right. The state, in preparation of your testimony, they gave you a CD or some sort of flash drive with a number of calls that they chose and asked you to review them, correct? So you could speak intelligently about them.
Yes.
Okay. So it wasn't a random sampling, it was calls that the state chose to focus on.
It's my understanding that the prosecution and defense decided on what could and would be played. So it wasn't just random, let me pick 20 calls out of a bag. It was calls that were relevant to the
Right.
case.
Yeah, right. I'm just saying it just wasn't some random sampling.
Correct.
It was focused.
Correct.
Okay. And so let's talk about some of the calls. We're going to talk about specific calls in a minute, but if you go back to what was played yesterday on that wiretap of Mr. Garlington's phone, there were calls, repeated calls about keeping Miles Farley, who's a small man, right? He is a small gentleman, physically small.
Small, yes.
Okay. Talk about keeping Miles Farley from being violated or attacked at the Rice Street Jail, right? We heard several calls about Miles Farley and keeping him safe.
Correct.
Okay. We heard call, and do you have the call logs in front of you or anything?
I do not.
Okay. When you were testifying yesterday, what were you using to keep track of what calls which?
I didn't have anything in front of me.
Okay. Well, we heard call 2532 from April 3rd, 2534 from April 3rd, 2628 from April 4th, 3501 from April 13th, and 3697 from April 14th, all about Miles Farley and being in jail. Do you remember those 5 calls?
I do.
Okay. Was Shannon Stillwell a party to any of those calls?
He was not.
Okay. We also heard a call 3683 from April 14th about, and you could probably tell me who the people were. It was Demekion Garlington and someone about flying a drone into the jail, it seemed.
Correct.
Okay. Was Shannon Stillwell a party to that call?
He was not.
Okay. Then we also heard about Demekion Garlington going on and on about running into someone named Blizzy at some hotel in Cobb County.
Correct.
Okay. To your understanding, was Shannon Stillwell present for any of those events in Cobb County?
No, I believe he was in custody.
He was in custody. So he wasn't involved with any of those things that Demekion was talking about, running into Blizzy in Cobb County.
Correct.
And then we also heard a call between, I believe, Demekion Garlington and Antonio Sumlin and it sounded, and this was call 3171 and 3172 from April 9th, about seeing someone wearing some jewelry, and they were asking if you have a slider car with paper tags. It sounded like they were trying to come up with a way to commit a crime, a robbery, right?
Correct.
Okay. Was Shannon a party to that call?
No.
Okay. And Shannon was in jail at that time, correct?
Correct.
Okay, so he was not involved in that situation at all either, correct? All right, cool. All right. I'm going to talk to you about specific calls that have already been played. March 14th, 2022 at 9:59 p.m. It's call 335, okay? It's a call where you testified, I believe, and correct me if I'm wrong, it was a call between Demekion Garlington and a gentleman named DeMarco Boyer.
That is correct.
Okay, and that's at 9:59 p.m.
Correct.
Do you know how many 9:59 and how many seconds? Are you aware of that?
I would have to look at the log for the seconds.
Okay. And in that call, Garlington instructs Boyer to switch to video.
Correct.
Okay. Now, based on your investigation, you said Boyer was at the gas station.
Correct.
And you also said, well, you were about to say, and then I cut you off. Boyer, your investigation has concluded that Boyer was in Mr. Nichols' car.
Correct.
Okay, so, and you're basing that on your investigation. You're also basing on the fact that Miles Farley in that video, when he goes back to the car, gets into the back seat at the BP.
That and there are calls from the wire that
Okay.
say that he's in the car. Yes.
Fair. So this call at 9:59 between Garlington and Boyer, your investigation is Garlington, this is your investigation, is Garlington is in Mr. Stillwell's rented white Audi,
Correct.
and Mr. Boyer, who's not charged in
Correct.
this case, is a passenger in Mr.
Correct.
Okay. Your investigation based on the time on the surveillance video from the FedEx surveillance is that the shooting happened around 10:01 p.m., correct?
I don't know if it's based on the time on the FedEx video.
Okay, well, what's your understanding of when the shooting occurred? If you know.
I don't know how they arrived at 10:02, but I know that's when both cars pull off shortly thereafter. Within probably a minute or two, the cars pull off from the gas station.
Okay. Now, what I want to know is, it's a matter of timing. The 9:59 and however many seconds that this call is made where eventually Garlington tells Boyer to go to video. That 9:59 and however many seconds is based on the clock used during your wiretap. That's where we get that time, right?
Correct.
Okay, so that's based on the wiretap time. Okay. So, and then of course, they hang up, then do you know if there was a subsequent video or FaceTime call?
I believe you could see the data transmission come through
Okay, and do you know how long that call was or exactly when it took place?
immediately after, but I would have to look at the log.
Okay. And my question is, we have three different sets of time here. We have the wiretap time,
Correct?
we have the FedEx video time,
Correct?
and we have a BP video time.
Correct?
Okay. Are any of those, to your knowledge, are any of those three separate surveillance systems synced up.
They're not. So typically what you would have to do is go back and sync them because I know the wiretap is a constant. I know that's an accurate time.
Okay, so you know, and that's fine. So you know the wiretap is an accurate time, but we don't know if the FedEx is an accurate time or the BP is an accurate time.
I'd have to look at the timestamps on both.
Okay, so I guess what I'm getting at is we can't just go by the BP time and go to 9:59 and however many seconds and say, oh, that's when that call was placed.
I went off of the wiretap data. Correct.
Right, and that's what you were in charge of the wiretap. You went, but I'm going to go back to my question, and that makes complete sense to me that you went off the wiretap time. But we cannot go back to the BP and look at the BP at 9:59 and however many seconds and say that's when this call was made. Because those two timing systems between the wiretap and the surveillance might not be synced up.
Correct. I'm not sure if they were or they weren't, but typically that's something I double check.
Okay, and the same thing for the FedEx. We can't look at the FedEx time and just go to 9:59 and however many seconds and say, oh, this is the exact time when that call was between Mr. Garlington and Mr. Boyer, between those two cars was made. We can't do that, can we?
Correct. I go with what I know to be constant.
Gotcha. So all you're saying is 9:59 on the wiretap.
Correct.
Awesome. Okay. Mr. Atkins or Miss Knight, and I should ask you, could you please publish what you played yesterday at call 350? I'm going to ask some questions first. Thank you. So, yeah, I'm going to give you a couple minutes. All right, I'm going to talk really slow because I got to give Mr. Atkins a couple minutes.
Okay.
Okay. So we listened to another call at 2:01 a.m. between, do you know who that call was between?
I'd have to hear it.
Okay, well, I'm gonna cut to the chase. You said in court that you heard someone say riding by the scene.
I don't know if I said that verbatim, but they're riding back through, I think is the direct quote.
And you said, but you said the scene.
They may have been riding back through the scene.
Okay, well, do you now know what call I'm talking about?
I know which call you're referring to, yes.
All right, and if you, and do you know who the speakers were?
Well, if it's from the wiretap, one would have been in Garlington.
Right.
And then I believe the other one may have been Boyer. I have to hear the call. I don't want to misspeak on it.
Okay, and people were fussing with each other. Someone was fussing with someone about not having a ride to get back to where they needed to go is essentially the gist of the call, correct?
Correct.
All right. Now, if you could play, if you could publish. Right, and whatever, okay, yes, if you could just publish, and I'm going to stop after about 40 seconds.
Bro, who that was? The nigga Ray got in that dance shit.
Okay, could you pause it?
Oh, for real?
All right, now, Miss Investigator Burrito, do you know who the speakers are?
I believe it's Boyer, but I need to hear a little bit more. That was
Okay,
kind of muffled.
that's fair. All right, Miss Hilton, if you could. Yep.
Yeah, RP, the YP Ray. Yeah, I don't even know him. That who got his chain snatched? That who changed little J5 to Jason? Oh, for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh, yeah, I had a J5 with me last night. That's probably what it was. Yeah. Yeah, that who changed it. Oh, damn, what I say, yeah. Buddy came and followed me. I followed his ass back. Hey, talking about what fuck wrong with him? What you talking about? I'm trying to get the other care data address right quick and care address. He testing the young crew. Somebody he finna send a bit. For real? Somebody he gonna send a bit somewhere late where the spot at.
Okay.
Yeah. He told LJ you got liquor last
20 seconds. And my notes might be wrong, but I don't think they are. Yeah, 20 seconds, please. Could you just tell me when you hear anything about the scene?
Okay, go
Oh,
ahead.
for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh, yeah, I had a J5 with me last night. That's probably what it was. Yeah. Yeah, that was J5.
Oh, no, I'm sorry. Yo, okay, I'm sorry. You're going by the different number. It's 2:01 a.m. Right, it's the PD, call 350. All right, here we go. This is the one I meant to pull up for you, Investigator Burrito.
Yo. All right, man. There's all kinds of shit going on. I just jumped in the other car, bro. Y'all niggas don't be getting dropped off and they ain't got no motherfucking ride to go back home to. That don't make sense. Yeah. It's supposed to be getting dropped off for a nigga ride with a nigga who wrote you. Yeah. That's stupid as fuck. So any of you niggas be on the gun or something. What's on with we right here down here. Y'all what? Ride past trying to see.
Okay, stop. Did you not just hear him say riding past through the city?
He said riding past trying to see.
Well, where's the scene?
I said,
You said scene before, now you're saying trying to see, and I'm saying city.
you may have misunderstood what I was saying. Or you got to understand when these calls come in, when you click on the call, it will also provide a map of where they are, and the next call may show where they traveled to after that. It's my understanding that he traveled back towards that area.
Okay, towards the area. You mean the city? It's in the city,
They never
right?
left the city.
Okay. Investigator Viverito, you previously testified that he said going to the scene, and now you're saying to this jury that he didn't say scene, he said see. Is that correct?
I don't know if I said he said, I don't believe I said he said he's riding through the scene. He may have rode back. I believe he was traveling back towards the scene.
And I know you're an expert, but if the jury listens to this and hears city, is that okay with you?
But that's not what's said, so I would clarify for them.
I understand that you want to tell everyone what's said here, but you've already given two different stories. You said C and C.
Objection.
Argumentative.
Overruled.
It's,
Can we just go by what we hear?
he,
Is that okay?
sure.
Thank you. Okay, call 416, and I don't need this published. Thank y'all. It's from the early morning hours of March 16th, 2022. Okay, there was actually two calls that were played. Do you recall?
Correct.
Okay, one is Mr. Garlington and someone that you say is my client, and the person's whispering. I'm not even going to dispute it, okay?
Okay.
We'll just say it's my client.
Okay.
Whispering about hiding in the crawl space.
Correct.
Okay. And then the second call is Mr. Garlington and my client talking about what just happened.
Correct.
And of course, what just happened was the house was shot up, and then a bunch of police officers showed up, and no one was arrested.
Correct.
Right. Okay. So, and that was the same day, of course, that you spoke to Shannon Stillwell. You put him in the back of the police car, or someone put him in the back of the police car, and you spoke to him, and he told you he was, in fact, driving the white Audi.
Correct.
All right. So, that call, let's just review some things that were discussed by Mr. Garlington and Mr. Stillwell. They talked about their amazement about not being hit by any of the bullets that were fired into 2830 Waters Road, correct?
Correct.
They talked about their amazement that the police let them go from that location.
Correct.
They talked about how they hid from the police.
Correct.
Mr. Stillwell talked about being placed in the police car.
Correct.
Mr. Stillwell said that he denied knowing McMain when asked and said he was from Thomasville.
Correct.
Okay? That was misleading, right?
Correct.
Because he does in fact know McMain.
He does.
All right, and McMain, just so we're clear, is Christian McMillan.
He is.
Yeah. And he talks about getting out of there as soon as possible. Like speeding away because he couldn't believe that y'all, the police, let him go.
He does, but he says prior to leaving, he collected his FN and his rifle or stick out of, and he left.
I'm going to get there. Okay. And they talked about seeing you too, right?
They did.
All right. So let's talk about, I know he, in that call, and clearly I'm getting there, he talked about sneaking his FN away from the scene, right?
Correct.
And about sneaking his stick out of one of the cars. I think the gray car.
Correct.
All right. Okay. Now, the FN, you've testified, you know that an FN 57 is registered in Miss Taisha Alexander's name, correct?
Yes.
Okay, and that gun was located at Meadowlark Drive on March 17, 2022.
Correct.
Correct? The next day after this call.
Correct.
All right. Does that FN shoot .40 caliber bullets?
Does not.
That could not have been the murder weapon for Shamel Drinks.
No.
Could it? Okay. He talks about taking a stick from the car, from a car on the scene, right?
Correct.
And you know the stick to be an AK-47 type assault rifle, correct?
Could be an AK-47. It could be an AR-15. It could be, it's a rifle.
Typically shoot 7.62 caliber bullets.
Correct.
Okay, not 40 caliber.
Nope.
Okay, so you would know that that stick that he talks about taking from the scene once you guys let him go is in fact not the weapon used to shoot Mr. Drinks.
Correct.
All right. And in this call where, again, you don't have any reason to believe Mr. Stillwell knew he was being recorded
Correct.
or Mr. Garlington knew he was being recorded. In this call, he never talks about taking any other guns from the scene.
Correct.
Okay. Okay. Call 2119 is another call that was played. It's from April 1st, 2022 at 12:29 a.m. It was a call between Demekion Garlington, who's on the wiretap, and Shannon Stillwell, who's in jail at this point, correct?
Correct.
Okay. And Demekion is on his normal phone, and you testified that Shannon Stillwell, when you're in the jail, you said there's wall phones, right?
Correct.
Okay, and that's, the jury has heard those recordings where they talk about Securus and this phone will be recorded, and they are in fact recorded.
Correct.
Okay. Mr. Stillwell was not on a recorded line.
Correct.
He was on a cell phone from the jail.
Correct.
Okay, so he, in common sense, he doesn't know that Demekion Garlington is being wiretapped.
Correct.
Okay, and he has no reason to believe that the cell phone he's using from the jail is being recorded.
Correct.
It's fair to say that they believe that they're having a private communication that is not being recorded.
Correct.
All right. Mr. Atkins, could you do me a favor? This call 2119, and I'm talking about at 12:29 a.m. Could you play on April 1st, 12:29 a.m.? I'm just adding. Okay, yes. You know how to make consult with the.
Yes.
we're just gonna do that call, okay? And I'm gonna ask you some questions about it. Thank you, Mr. Atkins. And if you could cue it up to 2 minutes and 40 seconds. Two 40.
I'm telling folks, bro. I'm like, shit, what the hell they locked up for? Like, they just saying about the pajama. I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. They gonna assume that, like, oh, like, y'all ain't did nothing to him, so.
That's what I keep telling Lil, I keep telling him, like, just chill. Like, I know,
Yeah, cause they
this
saying
ain't nothing. Yeah, I'm like, this ain't nothing, bro. Like, they just doing that cut. They seen as a goddamn gas station. Like, just chill. You see what I'm saying?
Yeah. Hell yeah, man. That's what I'm telling. I keep telling him all the time. Shit. I'm like, listen, bro. Just like you, like, bro. I'm telling probably in the cat. Listen, bro. No, just tell him before you don't want to talk, bro. Like,
Not one word.
yeah.
Go down on what they try to portray or what they say, man. Don't say shit.
Hell yeah. I ain't know that though. Like, so I didn't.
And you can keep that up because I'm going to ask you to play another part. But thank you, Mr. Atkins. So on that call, again, neither party has reason to believe they're being recorded. That's Demekion Garlington and Shannon Stillwell.
Correct.
And they talk about they gonna assume shit.
Correct.
Mr. Garlington says y'all didn't do nothing.
Correct.
And then Ms. Stillwell says they just saying it because they seen us at the gas station.
Correct.
Okay. Mr. Atkins, if you could please play 11:20 at 11:28.
Yeah, man. What the hell swimming on? You still in the yo?
Yeah. Okay, what is that?
You know what I'm saying?
Yeah, see.
Who? Yo, folk.
Yeah. Okay, what is that?
We're gonna come back to that one because I want to get the timing right.
Okay.
What's that?
Okay.
Okay. And that is okay. and we're gonna come back to that call. But let's talk about Mr. Stillwell's phone that was collected.
Sure.
Okay. Do you know you're able to view? So you collect the phones. Detective Leon Packer, he dumps the phones, and then you're able to view the phones, what the contents of the phones through a program called, what's it called? XRZ, is that correct?
XRY.
XRY. Okay. And you get just a whole bunch of information that's in whoever's phone. Pictures.
The contents of the phone are organized by category.
Right. And we're talking about pictures, text, emails, instant message, call logs, location, data, internet searches,
Correct.
notes.
Correct.
Okay. And if you don't know, that's fine, but do you know how many texts or calls total were in this phone?
I don't know off the top of my head, but it would be listed on the extraction, on the front page of the extraction. When you open it up digitally, it'll give you what you're going to see initially is it's everything by category. So it'll say 20,000 texts, 100 calls, things of that nature.
Okay. Ms. Knight, if you would please display 227 VVA2. Oh, Ms. Knight. VVA2. Yes. VVA2. 227 VVA2. A. Okay, this is one of the text messages or one of the text conversations that was introduced on Friday, I believe, correct?
Correct.
Okay, and this is from Mr. Stillwell's phone.
Correct.
All right, and in this phone, Mr. Stillwell's talking to, is that D, do you know that number to be Demekion Garlington?
I believe so, yes.
Okay. Because there's a couple of D's in this case, but you believe this to be Demekion Garlington?
He did change his number right before the wiretap, so I believe that's the number before.
Okay. And if you could zoom out a little bit, Ms. Hilton, or Mr. Atkins, so we can see the whole conversation. Thank you. Thank you, Mr. Atkins. So in this conversation, to add context, Mr. Stillwell is indicating that one of his two phones is at Big House.
Correct.
Okay. Do you take that to be Darius Ford's house? And again, let's be clear, this conversation occurred December 24th, 2021.
Okay.
Okay, so we're talking about 3.5 months before any of this involving Christian McMiller's death or Darius Ford's death or Shamel Drink's death occurs.
Correct.
Okay. Do you take that to be Big's phone? Is there another Big? Do you not know?
There is another Big.
Okay. So, but in any event, Mr. Stillwell is saying he left his phone at someone else's house.
Correct.
Okay. And then D says, finna take it in where you at, indicating that he's taking Mr. Stillwell's phone, right?
I don't take that as taking the phone, like finna take it in, like I'm finna go to sleep or go home,
Fair enough.
like take it in for the night.
Fair enough. Could you go down, Mr. Atkins? Okay, and this is the part that the state introduced. Okay. He says, if Polka asks, tell her I'm op hunting. Okay, he did not say I'm op hunting.
Correct.
He said, if Polka asks, tell her I'm op hunting.
Correct.
Okay, and Polka you know to be who?
Taisha Alexander.
And that is Mr. Stillwell's girlfriend at the time.
I guess, yes, I don't, yes, at
Something
the
like-
time,
something like
sometimes, yes.
And you also know from your review of the calls that Mr. Stillwell was having some issues with fidelity.
Yes.
Okay. So he's just saying, if Polka asks, tell her I'm op hunting.
Correct.
All right, thank you, Mr. Atkins. Mr. Atkins, can we go back to that call? I think I finally got my stuff together here. Okay, remember that call that we were just talking about with, and just to review, it's Garlington and Mr. Stillwell, and they were talking about people were going to assume things, and they're just saying it because they saw us at the gas station.
Correct.
Okay, I want to play, Mr. Atkins, if you could start playing it. I guess we could start at 11:28. Yeah, 11:45. Yeah, that's fine.
Yo, folk.
Yeah. I was there with him yesterday.
Yeah.
Yeah, he got out of town now. So he finna get ready to come back. I was gonna lie with his ass.
Yeah. You ain't talked all night. That whole night crazy, bro.
Yeah, I just talked to her today. I talked to her today.
Man, that be crazy.
I was telling her, I'm like, he on the cell phone, like, he probably be over there, like, what, no? She like, what? You really think you gonna tell on me? I'm like, man, hell nah.
She crazy. I don't even be texting her back no more.
I should be texting on, like, on the tablet and shit.
Yeah, I don't even be responding to her. That's crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get I'm gonna get up with you though.
I got you.
Look,
I know you.
Okay. Let me just ask you this, and we're going to get it together, and we're going to get it played. Do you remember on that call, that same call, that unrecorded call? I mean, that these two gentlemen thought that they were talking to themselves without being recorded. Do you remember Mr. Stillwell saying, when they test for gunpowder, it's going to come back clean?
I do.
Okay, and that's on this call.
Correct.
All right. And he does not say the car has been cleaned.
Correct.
He's saying, don't worry about it, because when they test for gunpowder, it's going to come back clean.
Correct.
Okay. And that was on the private call between Mr. Stillwell and Mr. Garlington that they had no reason to believe was being recorded.
Correct.
Okay, I'm gonna go back to the phone. You made note of 227 VVB11, and we don't need to display it, but it was basically something in Mr. Stillwell's notes that said, "Pop my shit. I really got options. Poor little ops. They be dropping."
Correct.
Okay, and that was in March 15th, 2022 at 12:52 a.m. The phone says that that's when it was entered.
It might say either modified or entered, yes.
Okay, and that was, and we're going to get to it, but you're aware that Mr. Stillwell's grandmother, Betty Jackson, texted him about the shooting, about seeing it on the news that night?
Objection to effects not.
Well, it's going to be in evidence. I'm asking if she's aware.
Overruled.
You're aware of that?
I was aware that Miss Alexander notified him about a shooting in Mechanicsville. I don't know if Miss Jackson did.
Okay, it was hours. This would have been hours after Miss Alexander alerted him as well. Correct.
Okay.
Correct.
I'd have to see it. I'm not.
Okay. All right. Well, we'll get to it. But this was at 12:52 a.m.
Okay.
Right.
I haven't seen it, so I just.
Okay, and we've already discussed ops,
Correct.
dropping ops. Those are common themes, common topics of drill music, correct?
Correct.
Okay. And at the time, your investigation, at the time that he entered this note into his phone, he was in fact at the studio, correct? At 12:52 a.m. on March 15th.
After leaving the gas station, they went to a studio. I did not have location data on Mr. Stillwell to say, but I believe they should have still been at the studio.
Still been at the studio creating music when he entered that note.
Creating music, hanging out. Like, yeah, that's what they do. Hang out at the
Okay.
studio.
All right, cool. And then you talked about search words, a search that you noted about a Windsor Street shooting, right? That was in Mr. Stillwell's phone.
So he didn't, and I clarified that on direct. He
Right.
didn't search Windsor Street. He searched Fox 5
Okay.
and then
Well-
clicked on, and then within Fox 5, then searched the Fox 5 website.
I appreciate that. So on 3/17 at 2 in the morning, Mr. Stillwell clicked on the Fox 5 website to this article.
Correct.
Okay, didn't search, your testimony is he didn't search words like Windsor Street or anything, but he clicked on the article and that's what shows up in the phone.
I'd have to see the screen. I believe he searched Fox 5, traveled to the Fox, like say I open my phone and I want to go to whatever web, Amazon, and search Amazon, click on Amazon. And then on Amazon, I would then search. That's what happened. So we searched for Fox 5, went to Fox 5, then went on Fox 5, I believe searched Windsor Street shooting, and then clicked on the article, is what it looks like.
Okay, and Miss Knight, could you just display 227 VV88 so everyone knows what we're talking about? Okay, so this is what you're talking about, right? The search.
Correct.
Okay, and that's and this is 3:17 at 2:31 and 56 seconds in the morning, correct?
Correct.
No, that's I want to show you some documents, investigator.
Sure.
It's okay with you. May I approach,
Yes.
Investigator Burrito, I am approaching you with what's been marked 57A, DS57A, DS57C, and DS50. Could you look at these and tell me if you recognize?
Sure. Okay, these are excerpts from Mr. Jackson's phone.
Right, and those are, well, and are those excerpts from, are those conversations from the data that was downloaded from Mr. Jackson's phone?
Sure, the first one is the one that I spoke about that I had seen of Miss Alexander informing him about the shooting.
It's not in the,
Oh, sorry. Yeah.
Are those accurate representations of the data that was in Mr. Stillwell's phone?
Yes.
Okay, Your Honor, at this point, I would move to admit 57, DS57A, DS57C, and DS58 into evidence.
A, C, and E. Say that again, please, if you don't mind.
It's, and there is no DS57B. It's DS57A, DS57C, and DS58.
Oh, okay. Don't know where the E came from. Okay. Those are admitted.
Mr. Kokomo, could you please, or permission to publish, Your
You
Honor?
may.
Mr. Kokomo, could you please publish 57A first? So in this, in DS57A, investigator, this is a conversation between Taisha Alexander, also known as Polka, correct?
Correct.
And Mr. Stillwell.
Correct.
Okay. At 3:14:22, at 11:01 p.m., Miss Alexander reaches out to, or texts Mr. Stillwell and says, "You okay? Somebody just got killed in the Ville. Ugh." Or ugh. Atlanta, too much right now, right?
Correct.
All right. And then they respond to each other with kisses. Mr. Stillwell asks who got killed, correct?
Correct.
And then Miss Alexander eventually says, "I don't know yet." But before that, she sends some sort of screen message, correct?
Correct.
Okay. And that's at this, the message is sent at 11:19:47 p.m., correct?
Correct.
All right. And Mr. Kokomo, if you could publish 57C. And this is the screenshot that, or the picture that Miss Alexander sent to Mr. Stillwell at 11:19 p.m., correct?
Correct.
And it's a photo, and is that Windsor Street?
I believe so.
Got killed in Mechanicsville.
Correct.
And it's posted by someone named Bori Billions.
Correct.
And at whenever Miss Alexander sent this picture or downloaded it, it already had 2,000 views, correct?
Correct.
All right. So by that night at 11 o'clock or 11:15 or 19, the word had spread about a shooting, correct?
Correct.
In Mechanicsville,
Correct.
where someone was killed.
Correct.
Okay. And this was not a secret. It was being spread throughout social media.
Correct.
Mr. Kokomo, if you could post DS58. Okay. this is a conversation, and I'm sorry, it's marked 58A, so Your Honor, if we could just amend that to make 58A.
Sure.
Thank you. So looking at DS 58A, this is a conversation between Mr. and Boss Lady, correct?
Correct.
And you know Boss Lady to be Betty Jackson, correct?
Correct.
His grandma.
Correct.
His grandmother who raised him.
Correct.
At 11, Mr. Thank you. At 11:19 p.m., Shannon texts his grandmother, "I love you."
Correct.
Boss Lady or Betty Jackson responds, "Mama love you so much, heart, heart, kiss, 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 'cause you're my sweet thing."
Correct.
And Mr. Stillwell says, "Yeah." I don't know if I'm pronouncing that right, but yeah, right?
Sure.
And then Miss Jackson gives a thumbs up, right? And then at 11:26:57, Miss Jackson says to Mr. Stillwell, or texts Mr. Stillwell, "Hope you are not near Windsor Street shooting on the news," right?
Right.
And then she says, "Answer me, please."
Correct.
And eventually at 11:41, 15 minutes later, Mr. Stillwell responds, "I'm at the studio, Mom."
Correct.
Okay. So at 11:26, according to this conversation, not only did Miss Alexander alert Mr. Stillwell about the shooting on Windsor Street, but Miss Jackson says there's a shooting on Windsor Street, right?
Correct.
And it's on the news.
Correct.
Was this information about the shooting on the news at that point?
I know that the article that in Atlanta, that wasn't like a ATL scoop or a news thing. And then I don't know how Miss Jackson saw it, so I'm not sure if you got word of mouth from Miss Alexander worried about it. I don't
Maybe
know.
she saw it on the news. Maybe
I don't know when the news coverage began.
Okay. The bottom line is, by 11:26 that night, two different people had informed Mr. Stillwell about a shooting, a death, Windsor Street,
Correct.
and the word had spread throughout. It wasn't just Mr. Stillwell that was being informed. The word had spread throughout the Atlanta community that quickly.
Correct.
All right. And basically, the phone indicates on March 17th, 2 days later, Mr. Stillwell clicked on a news article about that shooting.
We sought out the news article and then clicked on it.
Okay.
Yeah.
He sought out and clicked on it.
Correct.
All right. Cool. All right. Right when you started testifying, you remember when you were going through a timeline, and I think it was from 2019 to 2020 different events that had occurred?
I do.
And we heard a lot of names, Tanquarius Mender, right?
Correct.
And you said he's a member of the Rolling Crips.
As well as YSL. Yes.
Okay. And we heard about Stephen Harris,
Correct.
and he's a Crip. And we heard
No,
about,
I'm sorry. Stephen Harris is a member of YSL.
okay, he's a member of YSL. We heard about Marcus Sims.
Correct.
He's a Crip.
Yes.
Okay. We heard about Wayne Alford. And we heard about a bunch of other names in this
Correct.
timeline that you were going through. Well, first of all, let me just ask you this. When you were asked about all these events, you were referring to some sort of, you were refreshing your recollection with a sheet that was in front of you.
Correct.
Okay. That was highlighted, color coded.
Correct.
Okay. Did you create that sheet?
Mr. Abadi had created the sheet as a timeline.
Okay. So when you were testifying about those events, you were refreshing your recollection. You were being asked questions by the prosecutors, correct?
Correct.
And then you didn't have any reports of your own with you, did you? About any of these events?
No, I didn't. I was at DB at that time and there were 8 cases, so it wouldn't be my report.
You didn't investigate any of these events?
The way it would work is gangs typically doesn't take an aggravated assault or a homicide or things of that nature. We will work with those units and provide them information and assist with their investigations. So the reports, I will help with the cases, but they would fall with those investigators.
Did you have any reports with you when you were if your reports with you when you were discussing this?
No.
But you were refreshing your recollection off of a sheet of paper that was prepared by the prosecutor.
Well, this is something we had discussed. There's numerous incidents, so we needed a timeline to keep them correct.
All right, well, let me just ask you this. In all those things, 2019, 2020, that you discussed, all those events, Shannon Stillwell wasn't charged with any of those events, was he?
He was not.
Okay, cool. You remember when you talked about how I was asking you about your reports and you said you write them in search warrant applications?
Correct.
All right, I want to talk to you about that. You did a search warrant application for the house of Jeffrey Williams on 355 Allison Drive, correct?
Correct.
Not moving any evidence. I'm going to ask you some questions about that affidavit. Would having your affidavit that you wrote
Sure.
up there with you, would that be helpful?
Sure.
Pepper? Okay. These affidavits that you fill out to take to a judge to try to get a search warrant, they're under oath?
Yes.
Okay. A judge relies on them, relies on the accuracy of them, correct?
Correct.
Relies on them to be complete.
Correct.
The intent of an affidavit is not to mislead a judge, is it?
No,
Okay. And you wouldn't mislead a judge, would you?
I would not.
Okay. And you filled out this affidavit on May 9th, 2022, correct?
Following the presentation to the grand jury, yes.
Right, May 9th, 2022?
Correct.
Yep. And that was also in the wake of these various attacks on Lucci, on Rayshawn Bennett in the jail,
Correct.
okay? In fact, you were interested, you had that one with Jada Myrick, with Mr. Eppinger and Mr. Sumlin, and Mr. Eppinger was trying to get Mr. Sumlin to talk to someone to get payment, right? And you suspected that person to be Jeffrey Williams.
Suspected, and that was confirmed by Mr. Sumlin.
Okay, so you suspected that to be Jeffrey Williams.
Right, and was confirmed by Mr. Sumlin, yes.
Okay.
Yes, I
Just
suspected, yes.
questions I ask, okay? So you saw a search warrant for Jeffrey Williams' home for evidence on these matters, correct?
No,
Okay. You saw the search warrant for Jeffrey Williams' home.
for his body, for his cellular devices, and for gang evidence.
Okay. So, in Mr. Williams' home.
Correct.
In your affidavit is what's used to develop PC, or probable cause, for the judge to rely on, right?
Correct.
And in your affidavit, I think it's in the 4th page, you reference a post that you saw on the internet about Jeffrey Williams posting, YFN, and this is already in evidence, YFN, if I ain't like what you do for your mother and kids, I would have been killed you. right?
Correct.
That's referenced in your affidavit.
Which page is not on 4?
Well, mine's not numbered, but I'm just gonna go by. Right, it's on the 5th page, I'm sorry. If we count, and again, they're not numbered, but I'm just going by the 5th page that I have.
So
And it would be the first, it would have been the second full paragraph. So there's one sentence and then 2 paragraphs down.
1, 2, 3, 4, 5.
You can look at may I approach?
Yes. Okay, that's different than what I have.
You reference seeing on XXL this magazine, you reference seeing this post that Mr. Williams supposedly made, correct?
Correct.
Okay, and that made your affidavit because you thought that was important to show Mr. Williams and his veiled threats to Mr. Bennett, correct?
Correct.
Okay, cool. Can I have that back? I'm just going to need it.
Sure.
I'll bring it back to you. Now, you also, 2 pages after that, whatever page you have it, I have in the beginning, it says details 4.
I'm going to see the page because the pages are out. Whatever I have is not the same as yours.
You can have
Okay. No, I see that one. Okay. I gotcha.
it. All right. Also in your affidavit, you include a text thread between Mr. Wooney Lee and Mr. Williams, correct?
Correct.
And as part of this text thread, you draw the judge's attention to a specific line, correct?
I included that amongst other things in the affidavit. Yes.
Well, there's one particular line that you put in a bigger font and you also circled it, or it's circled, correct?
It's circled. Yes.
Okay. And you circled it to draw attention to it, correct?
To what I was referring to. Yes.
Yes. And the line that you circled to draw attention to was YSL rule the world, kid, 24M on an N head, correct?
Correct.
Okay. And you wanted to highlight that passage said by Mr. Williams in the text thread, correct?
Correct.
You wanted to highlight that for the judge.
Amongst other posts. Yes.
Okay. What was he referring to? Why did you feel it important to highlight 24M on an N's head to the judge?
Well, he's referring to YSL ruling the world
Yeah.
as an organization, and it could be a play on words or a play on things that have happened, saying 24M on a racial expletive head.
Okay, 24M on a racial expletive head. It sounds like Mr. Williams had money on someone's head.
It could be taken that way. Yes.
It could be taken that way, and you highlighted it and circled it for the judge, correct?
Correct.
Okay. And you believe that too. You wouldn't have misled the judge about what was being discussed, would you? You believed that to be a threat, didn't you?
I didn't say it was a threat. It's saying that he's willing to, that's how they talk. They'll talk about, they have the ability to put money on people's heads.
Okay. Mr. Kokomo, could you please publish Jeffrey Williams 3 and 4? Is that correct? Okay. Could you please publish Jeffrey Williams 3? Oh, before you do that, in this thread that you highlighted in your affidavit to the judge, this thread between Wooney Lee and Mr. Williams took place on February 7th, 2021?
Correct.
You just started over, Mr. Kokomo, with volume.
It's, we can put 24M on the front of your head. Y'all young hoes get in line. Slime rule the world. Believe it. Y'all niggas got this motherfucker spending 24 million on their heads. We can put 24M on the front of your head. Y'all young hoes get in line.
Okay, and could you please publish Jeffrey Williams 3? You see, what's displayed is Jeffrey Williams 3A.
I do.
Okay, and it's a reaction, Jeffrey Williams reacting after Lil Uzi Vert put a $24 million diamond into his head.
Correct.
Okay. Did you know about Lil Uzi Vert and the $24 million diamond and that reference when you filled out this affidavit?
I did not, but I would still stand by what I put in the affidavit.
Okay, so you're telling me right now, on a sworn statement to a judge with knowledge, that Lil Uzi Vert just got a $24 million diamond put into his head the days before Mr. Williams typed that, you would still put that quote, YSL ruled the world, 24 million on an end head in that affidavit?
Objection. Vague, compounded, maybe mischaracterization of what the witness just said.
Overruled.
I did not have knowledge of Lil Uzi Vert getting a diamond in his head.
Okay, so all right, so let me ask that last question again. Instead of saying I would do it again, if you had knowledge that Lil Uzi Vert just got $24 million diamond to mislead the judge?
Not misleading. May I explain?
Yes.
Okay. What I'm saying is this social media direct message is different than what you see on here. Lil Uzi Vert, I don't remember, is a member of YSL. So I think it might be a new, like a term they're going to coin, like wipe his nose, things of that nature. So 24 on somebody's head might be a new thing that they're going to go with. He's saying YSL rules the world. As the leader, he can make that assertion.
You're doing a lot of explaining. Did you do any of that explaining in your sworn affidavit to the judge?
The sworn affidavit reads, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. And clearly, when you put highlighted and circled 24M on a N's head, you're sending a message to that judge, are you not? Let's be real.
I'm referring to my words that I wrote. Say, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. As someone, enforcement officer, even with knowledge of this, you would still put that in front of the judge.
There are different interpretations to everything as we've seen throughout this whole trial.
I agree. Can we make our determinations, or are you going to make the determinations for us?
Objection. Our argument is
sustained.
Do you think maybe you misinterpreted what was said by Mr. Williams? Is that a possibility?
I think it differs from what was presented on the internet and between direct messages, as we've
Okay.
seen.
So your answer is no, your interpretation is perfect, pristine.
My interpretation was YSL rules the world and they have $24 million. That's what I wrote in my words in the affidavit. I didn't say Mr. Williams has $24 million on YF and Lucci's head. I didn't say that. I said YSL rules, he claims that YSL rules the world and has $24 million.
Now, you didn't say it, you just put in a bigger font and circled it for the judge, right? Right?
It wasn't a bigger font. That's how the message reads. It's the same font as the date and time, the same size as the date and time as the name, the Instagram handle.
In the circle?
It's circled, correct.
Let's talk about you, Ms. Knight, could you pull up 227 VV A6B? Thank you, Ms. Knight. Okay. Yesterday, you indicated that, now this is from a video,
Correct.
with Mr. Nichols,
Correct.
rolling a blunt.
Correct.
Okay. And then there's other individuals there, correct? There's other individuals in the room?
Correct.
Okay. And then it's on Mr. Stillwell's phone, so you're presuming that Mr. Stillwell was filming the video?
It was filmed from his device. So
Right,
yes.
right, right. Okay. So yesterday, you made a claim that a gun, well, what did you say? A gun is, I don't want to jumble your words. What are you claiming about the guns on this table?
A gun is what?
You identified or thought a gun was consistent with something?
It could be consistent with a Glock 27.
Could be consistent.
Correct.
Okay. And which gun is this?
The one towards the back right here.
Okay. Could be consistent with a Glock 27. All right. It could also, well, first of all, are you a firearms expert?
I'm not.
Okay. You're just someone who's owned a Glock before.
Several, yes.
Okay. And before yesterday, had you ever made the claim that, oh, I reviewed this video and this appears to be a Glock 20?
My first time testifying, yes. Where else would I make?
What about reports? Did you ever write a report and said, I reviewed this is very important. I reviewed this video that was in Mr. Stillwell's phone, and I believe that could be consistent with a Glock 27.
Well, while reviewing the evidence in preparation for trial, when I took a better look at this video and found it, it was probably 2 or 3 days before I testified. And that's when I first had to really research through and look at photos and kind of isolate what kind of gun that was.
So the answer is no, you didn't write a report.
No.
Okay. And certainly the first time saying it to me on this side was yesterday in court.
Correct.
Okay. You say it looks like it could be consistent with a Glock 27 based on the shape of the bottom of the grip. Is that correct?
Correct.
Okay. It could also be consistent with a Springfield firearm, correct?
I'm not familiar with a Springfield, but from how the magazine looks, also it could be consistent with a Glock.
Okay. It could also be consistent with a Sig Sauer. Could also be consistent with a Smith & Wesson, correct?
I'm familiar with a Glock.
Right, because you're not a firearms expert.
I
You're
never-
only familiar with these Glocks.
I never
And-
claimed to be Mr. Sharp.
Okay, well, You start identifying guns in court, kind of making yourself an expert, but you're not an expert, are you?
I'm not.
Okay. And you don't even know, whatever this is, if Mr. Stillwell left with that gun or didn't leave with that gun. You don't know if anyone left with that gun. You know whose gun it is.
Correct. We don't, that they didn't.
Okay. Right. Let me ask you this about your Glock 27 that you say this looks consistent with. When you shoot your Glock 27, does it expel shell casings?
I don't own a Glock 27. When I was purchasing a subcompact Glock, I was going back and forth between the 27 and the 43. I prefer to shoot a 9mm, so I went with the 43.
So you don't even own a Glock 27?
I just said when I was researching the two, handling the two at the gun dealer.
So now you don't own a Glock 27. You were researching it, which means you were handling the gun at the gun dealer. That's your experience with the Glock 27.
I never asserted that I owned one. I've seen one. I've handled one. I can recognize one.
So you've handled one at a gun dealer, and that's what you're basing the identification on.
As I've recovered a good bit of guns in my
Okay.
career. I know what they look like.
All right, let me ask you this. Since you know about guns, at least through your career, Glock 27s, when you shoot them, do they expel shell casings?
Yes.
Okay, Glock 27s, when you shoot them, do they make a loud bang?
Yes.
When you shoot a Glock 27, does it create a muzzle flash?
I should. I mean, when you
Okay.
shoot it, like during the day, you wouldn't see it, or sometimes at night you can see it, but
Okay, and when you shoot a Glock 27, does it emit gunshot residue?
if it's inside of a contained area, yes, it would.
Okay. All right. Remember on Friday you talked about you get to the end of an investigation, something seemed small is huge. And we were
Correct.
talking about the post. All right. Well, there's one thing, surveillance video. You would agree that that starts huge and remains huge? Like
Every-
surveillance video is a pretty important part of a case.
Every investigation is different, but yes,
Okay. You've seen the BP video, correct?
I have.
And you've seen it, Detective Hogan showed it to you?
He did for the purpose of identifying the individuals, yes.
Right, okay. Have you seen the FedEx surveillance video?
I have.
Okay. I'd like to watch it with you. Is that okay?
Sure.
Mr. Hogan. Okay, before you start, Mr. Kokomo, investigator, when did you first see the FedEx video?
It was after I met with Investigator Hogan in the afternoon of the 16th, so it would have been after that.
Okay. Were you aware that, and maybe this will help you answer this question, you're aware that Detective Hogan swore out warrants against my client without ever viewing the FedEx video?
I can't speak to what he did or did not do.
Okay. When did you most recently watch the FedEx video?
Probably maybe like a week ago,
Okay. How many times in total have you watched the FedEx video?
a few times.
A few times. When you say a few times, how many is that?
And I've watched it a year ago, or a couple years, like 2 years ago. I watched it.
Mr. Kokomo, if you could please publish the FedEx. Okay. Go ahead, Mr. Kokomo. Mr. Kokomo, if you could pause that video right now. Thank you. Investigator Viverito. At this point in video, as we have it paused, you would agree that Mr. Drinks' red Versa is on the left, correct?
Correct.
Okay. You would agree that Mr. Stillwell's rented white Audi with tinted windows
Correct.
is in the middle. And you would agree that Mr. Nichols, actually Miss Lewis, Mr. Nichols' wife, that Ford Fusion is on the right, correct?
Either the right or staggered behind it, yes.
And according to your investigation, Mr. Drinks is alone in the car,
Yes.
okay? Mr. Stillwell is in the car with Mr. Garlington per your investigation.
Correct.
And Mr. In the car, the Ford Fusion, we have Mr. Nichols driving,
Correct.
Mr. Boyer,
Correct.
and Mr. Farley.
Correct.
And your theory is that while at Mr. Stillwell shot Mr. Drinks, correct?
I'm not the homicide investigator, so I'm going along with the evidence that was presented to me by homicide. But yes, that's consistent with what Detective Hogan, his case.
Well, he swore out a warrant for Shannon Stillwell for actually shooting Mr. Drinks.
That's consistent with what Detective Hogan had found.
In this video, you could see headlights, correct?
Correct.
You could see traffic lights,
You can see taillights and traffic lights, yes.
and you could see brake lights, correct?
Correct.
All right, awesome. Mr. Kokomo, could you just play the video? And I'm just going to ask you to look at the cars closely.
Mhm.
Okay, pause, Mr. Kokomo, please. All right, so we're paused at 1:02:36 on this video. At this point, Mr. Stillwell in the white Audi is pulled off, correct?
Correct.
Okay, and Mr. Nichols and with Mr. Boyer and Mr. Farley have pulled off.
Correct.
Okay, while they were there at that light with Mr. Drinks, did you observe any muzzle flash on that video?
No. And with this quality of video, I would not expect to see it.
Okay. Right. Okay, I got you.
A muzzle flash is much, much, much dimmer than a brake light. Like if you're shooting at night, you're hard pressed to see your own muzzle flash.
Firearms expert again.
I'm telling you, my experience from shooting a firearm, we do take night firing courses.
So let me ask you this. Gunshot residue. You aware that the headliner from Mr. Stillwell's car, the Audi, was collected and tested for gunshot residue?
I am.
You ever talked to Alexander GBI analyst Alexander Coven about the results that he found?
I have not.
And you are aware that warrants were taken out certainly before any of those GSR results were in, correct?
Correct.
Talk about tint. You've been preparing with the state. You know that the state has said that Mr. Stillwell had tint applied to his windows of that white Audi upon renting it, correct?
Correct.
In violation of the rental agreement, I may add.
Correct.
Okay. And this tint was applied on Flat Shoals Road, according to the district attorneys, at about 6:30 p.m.
According to them, yes.
Okay. You were able to observe the white Audi on March 16th?
I did not walk. Wasn't that interested in it at that point, so I did not walk. It was very, very dark.
Have you seen the pictures that Miss Antoinette Green took of the white Audi after it was recovered when Mr. Stillwell was arrested?
I have.
Did you see any damage to the tint, specifically the front driver passenger tint on that car?
I did not.
Mr. Kokomo, if you could rewind again. No, actually, you know what? I'm sorry. Keep it here. Keep it here. Just play it. I'm sorry, Mr. Kokomo. Behind Mr. Stillwell? Stillwell, you're aware that he, well, you've already stated this, he was victimized in the past. Someone shot through the rear windows, killing Tiara Jones.
Yes.
Is next to Mr. Drinks, correct? Or approaching Mr. Drinks.
It's approaching, but it stopped short of Mr. Drinks.
Okay, Mr. Kokomo, if you could please play it. Okay. So now there's a pause. So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You could see from that angle that it looks like the front of the car. I'm sorry. The front of the car is like, from what I can see, looks like the front of the car. The front wheels are still towards the back of the vehicle. It's not like exact with the car.
Okay. Mr. Kokomo, if you could please play. Pause. See that car make a U-turn?
I do.
Okay. What car was next to Mr. Drinks when that car suddenly made a U-turn?
Judging by how the lights are, that car still appears to be back a little bit, but next to it.
All right, so now you're making three-dimensional evaluations, but we can't see a muzzle flash of this.
A muzzle.
AMV.
Mr. Sharp, I'm going to explain to you. When you're, I don't know if you're mischaracterizing it. When you go to the range, example, to fire your weapons at night, and there's a line of shooters, it's not bam, 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 lights everywhere. It's a very, very muted, if it shows. So this far away with this quality of video, I would not expect to see that.
Okay, well, let's talk about this car.
Sure.
This car makes a U-turn. Did you see, is there like a train that's crossing that would have let this person know, no, I need to find another route?
No.
Is there a officer saying, hey, turn around, you can't come this way?
No.
Is there an animal crossing the road that would have made this man do a U-turn?
No.
Who is this? Whose car is this that made the U-turn?
I don't know.
Okay. Do you know if anyone ever tried to use these license plate readers to determine whose car that is so we could talk to them about why they made that sudden U-turn?
That would be part of Detective Hogan's investigation, but I do not.
Okay. Could
And she said they were gonna make me famous, and it's happening, y'all. I'm becoming famous. Miss Sylvia, it was funny watching the other channel scramble for a live feed. We love you. Oh, thank you, Mimi. Thank you, guys. Sylvia always on her job. Amen. Amen. Amen to that. Yeah. What the enemy meant for evil, what? God turns it around for the good, right? Did you eat your food? Guess what? I've been buying them. I love them. Oh my God, Maurice, you turned me on. Oh my, and they feel so good in your gut too. Hey, y'all here. He's starting with me, y'all. He's starting with me. He's starting with me. He's starting with me. Thank you. How do I? Oh, y'all can listen to it. Hold on, we're gonna listen to it. We got a few minutes.
News and Talk 1380 WAOK. Now back to Let's Talk About It on WAOK. Call in with your questions or comments and talk about it at 404-726-1380 on News and Talk WAOK.
.1380 WAOK, your Sunday afternoon phone lines are open. We got our guests, y'all. Let me tell y'all, who did we just make famous? That's what we've been talking about. And the power of the audience, the power of social media, power of going viral. And let me tell you, it has changed the game. It's changed the game now. It's changing the game of our legal landscape. We're talking about courtroom drama on a whole other level. And of course, Atlanta, all up in the mix of everything else. Why not this too? Why not this too? So infamous Sylvia is on. Now, Sylvia is a trial vlogger. She is now known for her in-depth coverage of
Can y'all hear me? Like, I have been talking for a long time, and y'all know how I feel about talking to myself, and I just gave y'all a whole rant about how I don't want to feel like I'm talking to myself, and nobody said anything. So I'm about to get off. But first, I need to know if I was on mute, because I might have just cussed y'all out on mute. It's okay if nobody's here because there's nothing to see, so I get it, but I don't want to keep talking if nobody's listening. But I think I don't know if I was on mute when I just gave that whole spiel. Maybe I was. I don't know, because nobody's saying anything. So, well, I was gonna go back over what's been going on. I haven't been really paying attention to the trial. I've been in the car. I've been around my house. So I was gonna go back over it, but I'll do that to myself, and then I'll come back at 1:40, and maybe somebody will be here talking to me. Who is that? Hey, 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 Shawty. Do I know them? Do I know? Do I know you? You was looking at me like you knew me. I assumed that you knew me because you was looking at me like you knew me. Do I know you? Oh, well, hey. Nah, I'm sorry. Mm-mm. I can't have boyfriends. I'm gay. And my girlfriend don't want me to have no boyfriend. She don't like that shit. Yeah. My girlfriend crazy too. She be going through my phone and everything. Hmm. So we can't be friends. Cause I'm not trying to get in trouble with my girlfriend. Sir, sir, sir. I've told you very nicely. I can't give you my phone number, nor can I take yours. Because I'm gay. I have a girlfriend, and my girlfriend does not want me to have a boyfriend, nor does she want me getting numbers and talking to anybody. So I'm sorry. It's okay. It's okay. I just don't know how else to say it. You have a good day though. Be blessed. All right then. Huh. Okay. Whoa, what a weirdo. Am I on mute? Okay, so yeah, I'm gonna conserve my battery life.
I think that's argument.
Do you want to rephrase the question?
Sure. On the surveillance video, do you see at approximately 9:59 from the BP surveillance video, that car, Mr. Drink's car leaving the gas station?
I believe Mr. Drink's car leaves the gas station. And the other cars shortly thereafter follow.
And then do they then go to, those cars go to the light that's on the FedEx surveillance video?
Yes, they stop at the light.
Now let's go to the FedEx surveillance video.
Sure.
Right? Now, what time is on the surveillance video on the bottom? How much into the video are we at?
1 hour, 1 minute, and 32 seconds.
All right. Mr. Bob, if you can press play, please. Is that the red car approaching the light?
It is.
Right. Is that now the first white car, which is the white Audi, now approaching next to Mr. Drinks?
It is.
And is that the white Ford Fusion white Audi?
It is.
All at the light currently. And do we now see cars moving in the opposite direction?
Yes, oncoming traffic is starting to move.
And actually, Mr. Abadi, can we go back to when the cars first get to the light? I want you to tell me, I'm investigator, what time does the red car first get to the light?
One hour, 1 minute, and 36 seconds.
What time and tell me what time the Audi gets to the light?
At the 45-second mark, 2-second mark.
What time does oncoming traffic start?
1 hour, 2 minutes, and 11 seconds.
Are they still at the light?
They are.
What time does this car that's behind pull up?
1 hour, 2 minutes, and 24 seconds.
Do you see the white Audi pull off?
I do.
What time was that?
You may have to go back more because it's already pulled off.
You can go back to 102:11. Okay. We'll
Foot comes off brake at about 1 minute and 1 hour and 24 seconds. Or 23 seconds.
And prior to the Audi pulling off, do you see the, okay, let's go back. Can you go back to 102:15?
Oh, the fusion starts creeping up.
And what time is that?
It's around like the 7.
And is the white Audi going into oncoming traffic?
Yes, it darts into incoming traffic, oncoming traffic.
The lane that Mr. Drink's car in, is that the left turn lane?
It is.
The car that pulled up behind, does that car go left and turn left?
Yes.
And you said that you've been out to this area before.
I have.
Is the middle lane a turn lane?
No.
Is it only the left lane?
Yes.
Now, if we can go back again to 10215. Now, Investigator, I want you to focus on, remember the individual you saw walking in the video before?
Yes.
I want you to focus on that individual walking.
Okay.
And when if you can show the jury when you first see the person walking.
Right there. Or is it not on my screen? It is. Oh, there it is.
And you keep playing. Do you still see the person walking?
I do.
Are they still walking when the car makes a U-turn?
It is. They are.
Can you still see them walking?
But yeah, they're still continuing towards the intersection on foot.
And is Mr. Drink's car still sitting in the left lane?
It is.
Do you still see the individual walking?
You see, surfacing right here. It's very hard to see, but you see the movement right here.
And he's still walking towards the light?
Correct.
On Windsor Street, where the individual is walking, what is to the right of where he's walking?
I believe I remember correctly.
Now, we're gonna have to go back again to about 10211. Again, is that where all three cars, the Fusion, the Audi, and and Mr. Drink's car all at the light?
Correct.
Now let's focus our attention on the car that pulls up. What time does the car pull up?
At about the 27 to 28 second mark at 1 hour, 2 minutes, 27 or 28 seconds.
And I actually want to pause. Mr. Abadi, are you able to zoom in to that portion now? And once you zoom in, if you go back to 10211. If it's not working, we can just go back. Thank you. Is that just a zoomed in area of the location that we just been looking at?
It is.
All right. And now I'm going to focus on a white car that pulls up. Do you see the fusion pull for it first?
Correct.
Is that the Audi pulling off into traffic?
Correct.
Now, is the white car behind those cars?
It is.
And from here, can you tell if the car that pulls up is behind the car with Mr. Drinks?
You'll see like a gap here. It's like the tires are back towards the back of the car.
In the turning lane?
It's in the middle lane.
Okay. Keep going. And do you see the car flash on and off and the car still behind Mr. Drink's car?
Yes.
Right. And is that light red?
It is.
And does the light turn green when he goes to make the left turn?
It is.
Following road traffic
Correct.
or following the correct signals?
Correct.
And is the car still sitting there?
It is.
At any point in time in this video, do you see any muzzle flash?
No.
But was Mr. Drink still shot inside of that vehicle?
Yes.
Now, when the Audi that Mr. Stillwell takes off, does he go left as well?
Yes.
Right. I want to go back to 397 VVD. And I want to go all the way up to the top initially.
Okay.
This exhibit. Now, do you see the top, the categories of the information that's contained within this exhibit?
I do.
The March 14th, 2022. And I want to scroll to when we last looked at this document, 9:59.
He was.
Okay. At 10 o'clock, was this at 464 Winter Street?
He was.
That's the same BP gas station.
Correct.
All right. At 10:01, was the income monitor at 405 Cooper Street Southwest?
It was.
Right. And do you see that column I where it says 17 and 18?
Correct.
All right. And that's the miles per hour, right?
Correct.
Okay. When we go to 10:02, PV2 plus VR, is that at 18 seconds?
18 miles.
18 miles per hour?
Yes.
Excuse me. And I want you to remember this PJV2 location, all right?
Okay.
The next location, 500 Northside Drive Southwest. How many miles per hour?
90.
And what time is that?
10:03.
Is that 2 minutes after the car is at the, or the ankle monitor at the PJV2 location?
A minute.
Excuse me, a minute after the PJV2 location,
Yes.
right? I want to show you 397 VVF.
Yes.
I don't know what the, Mr. Shard's gonna tell you why he objected. I had already asked the witness the question about the 90 miles per hour. So that question was done. My next question, I asked her to read the location of PJV2. That's it, what was on the spreadsheet. Then that is when Mr. Shard objected. So that is the objection that's on the floor. At this point, I've asked her to read PJV2.
Well, she is reading off of an ankle monitor report from the ankle monitor company. To the extent that she reads off of it, that's not really my issue. It's when she starts to interpret the data. She doesn't work for that company. I don't know, for instance, the PGV2, whatever, PJV2, I don't expect to hear her testify or what that means, because she's not the ankle monitor person. The ankle monitor person would have been the person to ask about those things. So I don't get.
What is VJV2 say?
So the next thing that I was gonna show her, which was already admitted, is the picture of PJV2, which is a location that's already in evidence.
But how does she? Okay, so
What you were gonna ask her to read.
Yes. So this is the spreadsheet, Your Honor.
Okay.
On here, which I had her read earlier on the spreadsheet, the column has the name, column D has the date and time, column E and F is longitude and latitude, and column G is a location. So before the objection, I believe she was reading, or she had read at March 14th, 2022 at 10:02 p.m. the location PJV2 plus VR, Atlanta, Georgia. That is what my question entailed. And that was the
Okay, and
objection.
she read that?
She
Or
read,
is- Okay, she read PJ plus VR, Atlanta, Georgia?
I believe that. if
Or
the
is that when
objection-
the objection came?
That might have been when the objection came.
Okay, and then what?
And I was just gonna have her read the date and time of that location. Then I was gonna show her what has been admitted already as already admitted as 397 VVF.
That plots that location
Correct.
by the ankle monitor company? Or by whom?
We showed the ankle monitor company that picture as it correlated to this location here. So we printed out Google images of these locations, PJV2, 464 Windsor, which is what I just showed her previously.
By the latitude and longitude?
Yes.
Somebody plotted latitude and longitude
I don't.
on a map
No, we
to get
pulled
that
up-
location?
We pulled up the map. We went into Google and we put PJV2 plus VR. We just Googled it. And we pulled up the location.
So essentially, they want someone who doesn't work for the ankle monitor. And mind you, the ankle monitor company person is already here. They want someone who doesn't work for the ankle monitor company to take something that's on the ankle monitor company's Excel sheet and then compare it to a Google printout that the prosecutors printed out, and
That is already in evidence?
That's
You're right,
already in
it's in evidence. It's not, we're not admitting it through her. It's in evidence. The ankle monitor witness introduced it. He
Okay.
introduced it along with the record
Mhm.
of the pictures. And so
Okay.
at this point, when Mr. Shard has
Okay, and
challenged.
then what? So you'll then say, and here's these events that is a plot of V2 plus VR.
Is that the location at the light that for the surveillance video that we just observed? Because all
Okay.
of this is in this is all in response to Mr. Shard's cross-examination about what occurred at the light.
Can you put that back up again, please? The thing that was just up. And from this, you are going to have her extrapolate that because at 10:02, his ankle monitor showed him at that location, then what? Because you came up here and were saying this is going to be able to show that the timeline is accurate across all the different devices. How is it going to do
So
that?
the challenge that Mr. Shard made is that the 9:59 phone calls, this started with the phone call at 9:59, which is the wiretap phone call. Mr. Shard asked Investigator Burrito, are you able to know if that is the accurate time? Because of that line of cross-examination, we are now showing Investigator Burrito other admitted evidence that shows a correlation to that 59 time. So when you look at this chart, before we get to the 10:02, which is at PJV2, at 9:59, the
Please
ankle.
put that exhibit back up. Or hand it to me. I'm happy to have a paper copy of it. So now we're talking about 9:59 and not 10:02.
You're right, we're showing Mr. Shard started off at 9:59. Then if you can recall, he went through the entirety of the surveillance video at the FedEx. So that's after 9:59. So what we are showing is other evidence that
he does not dispute that he was at the light.
He disputes
at the same time as Mr. Drinks was.
Your Honor, he disputes that Mr. Stillwell is the person who was shooting. He disputes that the call at 9:59 was a call to get on FaceTime to shoot Mr. Drinks. We are saying that that call, that FaceTime call, is a call that where they said we are getting ready to go shoot the ops. That's why they get on FaceTime. So he is challenging all of that, Your Honor. So what we are showing is at 9:59, if you look here on the ankle monitor, he's at 464 Windsor Street. That is the gas station. He then
59 accurate.
Here's
up to. I mean, you can establish that 9:59, according to the ankle monitor company, is spot on to the second. 9:59, according to the wiretap.
But we're saying that it's accurate time, Your Honor, because he wants. He's at 464 Windsor, which is where, if you look at the BP gas station video footage, that is when all the cars begin to pull off from the surveillance video at the BP gas station.
But there is no cross-reference to the wiretap, which is the point. That's my only point is 9:59 on the wiretap. We don't know when it is on the rest of these devices. And this information does not give us or other surveillance systems.
Agreed.
And
Do you have him on the video at the BP station talking on the phone and going like this?
We have the wiretap that has him, we believe, the phone plot.
I know you believe it. Do you have evidence to establish it?
Our evidence, circumstantial evidence that he do we have direct evidence? No.
Do you have evidence that the 9:59 is the same 9:59 on all of the different things recorded time?
Circumstantial at all these times, Your Honor, because when we look at the ankle monitor information, he is at the 464 Windsor at 9:59. The call comes in at 9:59. The BP gas station surveillance video has 9:59. So we are showing that all of these things coexist. So the time could not just be off because all of the time are at approximately 9.
That's if he got the call when he was still at the gas station.
Your Honor,
The fact that they all at some point say 9:59 doesn't establish anything if you don't have a video that shows him talking on the phone at 9:59 so that you can go, aha, see, the video lines up with the ankle monitor that says 464 Windsor Street. Otherwise, it's just what you want it to say, but it doesn't actually, even circumstantially, establish that. You can argue it, but you can't have a witness say, yep, this says 9:59, so that means
but we
that's
didn't
when that.
ask her to say that. Your Honor, that we never asked investigator.
But
Viver. We asked
I
her
know,
what
but
time
you were telling me that's what you were
No,
leading up to having her say.
No, it's not, Your Honor. What I said I would never have her say, is he exactly on the phone at that time? Because he's in a tinted car, so we don't know. What we know is from the wiretap that at 9:59, there's a phone call. That's what we know.
That
So I
at
can never-
9:59, according to however the wiretap clock was running.
Correct. Your Honor.
Yes,
And that's
nobody
what I'm at.
disputes that.
Your Honor, we've stopped talking about
Ms. Hilton, you
9:59.
came up here and said, I'm asking these questions so that I can establish that the timeline lines up for everything.
Yes, Your Honor, the timeline lines up. So
Okay.
at this point, I can show that all of these different devices are around approximately the same time.
I don't think anybody disputes even that it's approximately the same time.
Mr. Shard does. Okay.
You can have her, it's in evidence. You can have her read something, but you cannot have her say, yeah, that means all of these times lined up.
I
Or that
never was
means
gonna have-
9:59 here and 9:59 on the wiretap were the same thing.
We never had her. We were finished with the 9:59, Your Honor. The only thing I had just asked her was about PJV2 when he objected. We were finished with 9:59 about 5 questions ago. So the only thing that Mr. Shard objected to at this time was that she was reading PJV2.
No,
That's
that
what the
she was
objection-
about to interpret.
She was not, and that's the thing. That
Okay,
was-
well, great. She's not going to.
Okay, well,
and that wasn't the state's intention.
Okay, then I have no idea why you think any of this is going to establish that all of the times lined up, but.
I'm going to object on relevance grounds at this point because I don't know where we're going, but it seems that they were trying to establish something. They said they're done establishing that, and Investigator Viverito is still interpreting ankle monitor data. So I'm going to object to relevance in 403.
Your Honor, as I stated earlier, Mr. Shard has challenged what occurred at the light.
I know.
So at this point, we're just showing, based on admitted evidence, what occurred at the light, Your Honor. That's all.
Can I ask a question? Why is it improper or not relevant? So if there has been questions and testimony about whether the times for everything sync up, I think has been Mr. Sharp's his argument the entire time. Well, in the screenshot that was admitted to Detective Hogan and
Okay, I didn't rule that it wasn't relevant. What we discussed up here at the bench was that it's not within the scope of redirect, which is when Ms. Hilton said, oh, yes, it is, because I'm going to be establishing that all of the times line up.
But on cross, he disputed that the 959 from wiretap was anywhere close or could be related to the 959 anywhere else.
Was established as being the same 959, and I have heard nothing that, maybe you could tell me how you can establish.
So not he is at 464 Windsor Street. Okay,
Because some other item of evidence says it, and we don't know that they're all running on the same clock.
That's what we're trying to show you it is, because at 9:59, if everyone would just wait, and we'll get to the big ta-da. So at 9:59 on the wiretap thing, it says 464 Windsor Street. On the ankle monitor, on a separate device, at 9:59, Mr. Jack, the exact same place at the exact same time. At 10:02, it shows that he's at PJVR2, whatever. That's the intersection of I-20 and the light. And then at 10:02 on the FedEx thing, and it says 10:02:17. So it's the exact same thing. It's to show that all the times line up. All this questioning that the times are not accurate, that the times don't sync up. We're proving that they actually do sync up, which is what he challenged Investigator Burrito about this 9:59, and she's just making it up, and all the evidence is being presented as how she wants it to. And now we have physical evidence from different videos that show they actually all do sync up, that they're all running on the same, time width or band, whatever.
I think you can argue that. I don't think that is established. But if you want to have her say, but Ms. Hilton says y'all already left 9:59 anyway. So I'm still at a loss as to where we are. But we'll just get her back in and.
I have a motion before the jury comes out, you bring her back in, because unfortunately, it's my job to further tax the patients in court.
What's that?
Yeah, I have a motion to strike the testimony of Investigator Viverito as well as any evidence that came under her. And the reason to make this motion, Your Honor, yesterday it came up that she had been following the case. The court asked.
That she had been somebody had mentioned her on Twitter.
Okay, and your opinion would have been different if she was following the case?
No, if you know that she was following the case, that doesn't exclude her as a witness. You can let the jury know that.
Okay, because
You can ask her that.
I can ask her about her following the case?
Sure, and we'll see what she says.
Okay,
And if that's so, then it still doesn't exclude her testimony. Well, she may know some of this other stuff from listening to some other witness.
okay, because what I would like to get into, and we may as well bring it up now before the jury is here, is that she got into an altercation out in the hallway with Kayla Bumpus.
Why
where-
is that relevant to the guilt or innocence? of
I'm
these
about to go there, Your Honor.
Okay.
Just let me finish a second. She got into it because she was watching Kayla Bumpus' feed about this case, and Kayla Bumpus apparently called her.
Okay, you may get into whether she has been tracking this case.
Mhm.
You may not get into whether she got into a dispute with somebody
gets into
about
her-
their posts.
It gets into her bias against these defendants, Your Honor. It goes directly to it.
What are you proposing to ask?
I'm proposing to ask if she told Kayla Bumpus in the hallway that was the last time she was going to call her a hoe. It goes direct.
I'm sorry, the last time who was going
That
to call?
Kayla, sorry for the pronouns, that Kayla Bumpus was going to call Investigator Viverito
We need to
a
get
hoe.
into who it was, or just that somebody.
I think we need to get into who it
Why?
was.
Why?
Because she's married to Mr. Jackson.
Well, was she at the time? Is this for real, y'all?
Yeah.
None of this is relevant.
Well,
None of this is relevant. Whatever is happening between Ms. Bumpus, Mr. Jackson, this has nothing to do with the guilt or innocence.
Unfortunately, the bias of a witness, well, fortunately, or I strike that. It is not fortunate or unfortunate, except for the fact that it is dragging this case on even longer. But a witness's bias towards a party may always be shown.
If she isn't, if she
At the same time, might qualify.
If I
Yeah.
just maybe concur, I don't know. I'm not the proponent of this evidence. I'm hearing Mr. Weinstein out, but my silence should not be viewed as acquiescence that I believe this should be admitted. I need to hear what Mr. Weinstein's saying because I may have an objection myself.
What I'm saying is that if there is a relationship between Miss Bumpus and the defendant, then Investigator Viverito's bias against that.
Against being called a bad name?
No, if she is in an altercation with someone that's in a relationship with the defendant, I think, and especially if it is a threat, because
How is that a threat?
that's the last time you're going to call me a hoe. I mean, I've had clients arrested
for less.
I'm not fitting the case